Yes.
My lord, may I be permitted to mention, my lord?
Inclusion. Inclusion.
Inclusion. My lord. So these are two probate proceeding and one partition suit. My lord, they have been settled, and terms of settlement was filed on 17th October 23, my lord. The matter has since then not appeared, my lord. But may these matters appear before your lordship, my lord. These are 2014 and 2016, my lord.
Check it. Date they can.
But my learned friend is appearing for the other side, my lord.
May I have my lord kindly to mention one matter. It was mentioned earlier when your lordship directed the matter to appear last Tuesday for filing of terms of settlement, but matter didn't appear. May I pray for it to include and appear on
Testamentary.
testamentary?
My lord, I appear for the
Thursday.
defendant, my lord.
Thursday.
My lord,
no.
lordship may kindly keep it on Monday because the terms of settlement.
Tuesday or Thursday?
My lord, Thursday week, my lord.
Thursday.
Thursday week.
Okay, Thursday.
Thursday week, my lord.
Either Tuesday or Thursday. Testamentary matters either on Thursday or Tuesday.
The next Tuesday, if your lordship.
Next Tuesday, okay.
Next Tuesday.
Tuesday week, my lord.
Tuesday.
17th.
Asking the Tuesday. Next Tuesday.
Next
Or
Tuesday.
Next Tuesday.
May I have my lord's kind to mention a matter, your lordship being CS number 84 of 2012, your lordship on previous occasion the matter was listed. My learned friend appearing on the other side said that there is no instruction of such settlement and he'll come back with instructions. And the matter was supposed to be in the list today, your lordship. However, it's not appearing in the list. May I humbly request for it to appear in the list, your lordship?
Testamentary.
No, your lordship. This is a suit, your lordship, for recovery of money, my lords. And your lordship, the matter has been settled, my lords. What had happened on previous occasion when the matter was listed, my learned friend who's appearing from the other side said
Tomorrow or
that,
Friday, check it.
great.
May I have your lordships kindly to mention a matter? It's a company petition. We are for the secret creditors, your lordship. The company has been ordered into winding up. Order has been passed in 2015. Till then, no effective steps have been taken. I'm praying for inclusion in the list. We have filed a transfer application for the incident.
May be permitted to mention, lordship, one application matter, lordship.
Inclusion.
Inclusion. May I have your lordship's kind leave to mention a matter where the special referee's mandate is expiring on the 12th of December. Will require some more time. May it come up as to be mentioned for extension.
Tomorrow.
Testamentary matter for inclusion.
লর্ডশিপ দয়া করে অনুমতি করলে একটু প্রার্থনা জানাবো এই পার্সেন্ট
হ্যাঁ বলুন।
লর্ডশিপ 3rd ডিসেম্বর অরিজিনাল সাইড ম্যাটার আইটেম নাম্বার 1 লর্ডশিপ দয়া করে আদেশ করেছিলেন আজকে লিস্টে আসবে, কিন্তু লিস্টে আসেনি।
আসেনি?
না, লিস্টে দেবার জন্য আমি একটা তারিখ প্রার্থনা করছি।
টেস্টামেন্টারি।
টেস্টামেন্টারি শুট
বৃহস্পতিবার দিন আসবে। হ্যাঁ।
Origin side commercial division item number 1.
Lord, I appear on behalf of the plaintiff,
Well, I have
pursuant to your lordships. Lord, pursuant to your lordship's order dated 11 June 2024, my lord, the witness action of the plaintiff has stood completed. My lord, I have a very humble prayer before your lordship. My lord, by the order, your lordship had appointed, my lord, the learned commissioner, my lord, to finish the commissioning. Lord, I was humbly praying that if the same thing can be done in respect of the defendant's witness as well, my lord, bearing in mind that this is a commercial suit, my lord, to expedite instead of having the witness action in court, if the same learned commissioner can, my lord, be appointed, my lord, it will just help in expediting the suit. My lord,
May I file my report, my lord?
You are the commissioner.
Yes, my lord. May I
This
file
is for PW.
PW, my lord? My lord order says for the plaintiff witness which has been completed, my lord. This is
Now,
my
so far
report.
as the defendant's witness is concerned.
Objection to that, my lord. But my lord, I have filed an application, my lord, under order 7.
Yes.
My lord, that is fixed on
17.
Yes, my lord.
16. Now, my lord, on the previous occasion on 21st November, your lordship directed me not to exchange affidavits. Now, my lord, time has lapsed. My lord, they have not used any affidavit. So, my lord, let the matter.
So let that go on separately.
I am in default.
Let commission work be progress.
be heard out, my lord. My lord, if my lord, the suit do not remain, my lord, then
In that case, there will be no evidence. Evidence will be expunged.
let
Yes.
it be, my lord, may I say this, my lord? My lord, let the matter be heard out on 16th, order 7 rule 11. My lord, there are
Exchange of affidavit is complete.
My lord, I am in default of your lordship's order. My lord, the affidavit is ready. It only has to be affirmed. My lord, we'll file that. My lord, that can proceed independently, notwithstanding.
All right, come on 16th. I will finish it on 16th.
May I file my circulate the report also, my lord?
Come on the next date.
May I file my report, my lord?
Okay.
It was
The learned commissioner, advocate commissioner has submitted his report. You are paid. You are paid.
yes, my lord. May I circulate the reports also, my lord?
Copy of the report may be handed over to the learned counsels. When it's 16 December was fixed, which is the order fixing 16 December?
Last 21st November, my lord, your lordship has passed an order, my lord.
10 December.
In December is, my lord,
Where is order on order 7 rule 11?
My lord, today the time for the learned commissioner has expired. My lord, I was praying for an extension so that the defendant.
Fresh order will be passed. Let it be heard then.
May I be discharged till that time?
Lord,
I'm not discharging him as yet.
my lords, my lords. My lord, I was humbly praying since the GA is also appearing. Lord, GA4 for order 7
Where is
rule
that
11.
order?
Lord, that is Lord order dated 21st November. Lord, I was seeking a short extension to file my affidavit in opposition to the GA4, which is the order 7 rule 11
Order
application
ta
on behalf of my learned friends. Lord, short extension, Lord, week's time will be enough for us to file.
It will appear on 16 December.
Yes, my lord.
File affidavit and reply in the meantime.
opposition, they have not
But
filed yet.
opposition I have to file, my lord, to the
So thing will go, kept on pending.
Lord, I
AO
should file.
reply, all these things will go on.
Yes, my lord. My lord, I'm in default, my lord. First extension, my lord, I was humbly praying.
So don't insist on going ahead with the witness action. You are at default.
My lord, there is no my lord, stay of suit, my lord. The suit can proceed, my lord, with the greatest of respect, my lord.
Look, one practical difficulty is there, you can understand. He is supposed to pay some money for the commissioner.
My lord, on instructions, my lord, I'm submitting. I've taken instructions. We are willing to bear the costs of the commissioner in order to
Then it
expedite
will go on.
The order 7 rule 11 application.
completely independent.
All right.
Lordship's order, my lord.
কোথায় অর্ডার কোথায়? আমি তো অর্ডারটা চেয়েছি দেওয়ার জন্য। And next para, an extension is sought for to file affidavit in opposition against GACOM 4 of 24. Full stop. Affidavit in opposition shall be filed on or before 16 December 2024.
I'm grateful.
The suit will appear in the list along with GACOM 4 of 24 on 16 December, the date fixed.
My lord,
I'm
have to
deeply
file a
obliged.
short reply to that, my lord. If the, my lord, they,
Unless it is filed, how there can be replied? Let it be filed.
they have not, if they will not file an opposition, my lord, we will again have to,
I will hear the application then. I will pass order regarding the application.
I have to again pray for an extension to file reply. But this is the difficulty.
Yes. You have to file reply. There is no cause of action for reply as of now.
I'm grateful.
Of course, you will be given opportunity to file reply.
Item number 2.
Lordship, I appear on behalf of the petitioner, my 34 application.
What is GACOM 1?
Lordship,
This is the
it's an intervention application. It's an intervention application. The respondents are.
we have filed our opposition to the intervention application. But the principal application is 134, one execution, and one stay application of the award. In that principal application, my learned friend comes
This is
and says
EPICOM.
they want to file an intervention.
My lord, on last occasion, my other side gave a consent that they will give us time to file the affidavit in reply. On that basis, my lord had kept this matter today, my lord, that we will be seeking.
You file affidavit in reply.
They will have to file. They will have to file. We have filed opposition.
Where is opposition?
We have filed within time the opposition. Intervention does.
We have,
GA one
we may
time.
not have filed it. Stating we may not have filed.
No,
it.
we've served,
We
we've served.
have served.
If it is not there, my lord, we will file it, but we have already served.
It has been
It has been affirmed within time. এতগুলো কলমের মধ্যে আমাদের আমাদের একটাই my advocate on record will give it, my lord, but we have already served within time.
My lord, what had happened?
File AO.
we have performed.
During the course of the day.
Affidavit in opposition is yet to be filed. Affidavit in opposition against GACOM 1 of 24 is yet to be filed. Mr. Shen, the learned senior counsel appearing for
Award holder.
award holder. 6 for time to file affidavit in
In
opposition.
the course of the day, my lord, because it has already been solved.
Affidavit in opposition and affidavit in reply shall be filed on or before the returnable date. Let the matter appear in the list on 15 January.
And main অন্য matter গুলো কবে
আছে 13 তারিখ
13 But the reply will be served at least 2 days before the returnable date so that we can.
Copies of affidavit in opposition as well as affidavit in reply shall be served prior to the adversary.
Grateful, my lord.
Item number 3. Item number 3, my lord, I appear for the plaintiff, my lord. This is my innocuous application for, my lord, amendment of name of the company. Lordship will kindly take, my lord, page 11.
and was it changed?
The name of the plaintiff, my lord, has been changed from Tyson Group Elevator India Private Limited to TK Elevator India Private Limited. That is one. And this, sorry, my lord.
Originally Fremont Novo Sciences. Originally it was Fremont Novo Sciences. Then it became Tyson Group.
Yes. And now it is TK Elevator
TK
India
Elevator.
Private Limited. Suit was filed in the name of Tyson Group. Lord, and the second is page 12. Lordship will kindly take the principal place of business. That it is has been changed to, my lord, 14th. Lordship will find the fifth entry, page 12.
Delhi. It is Delhi.
No, Kolkata. Lord, page 12, serial number 5.
Now it will be Salt Lake City.
Yes, principal place of business. It was my lord, Eastern Zonal Office. It was written as third. Malik Court 39A, Harish Mukherjee Road. The amendments are indicated, my lord, page 17 onwards.
এটা তো GST
Mailing address is 429. That would be possible in the corporate office.
Yes, yes. That is the registered office.
No.
Function that Delhi is the registered office. Lordship will kindly take the cause title. It's first page of
Principal
the,
place of business. Okay.
the principal place of business within West Bengal has changed.
নতুন
Mr. Ghosh, have you any objection?
Normally, I wouldn't have any, I don't have any objection. Only I didn't understand this last part. The page 19 is the only amendment he has sought. Page 19 and page 20. So he has deleted that they no longer carry on business in Harish Mukherjee Road. Is that it?
Yes.
And that
And
was
now the
there.
principal place of business
So this
is
was already
Salt Lake.
there. না না এটা সল্ট লেক তো ছিল তো it's not
It's
then
indicated in that.
so in my copy it's not indicated in red which
You
is
check,
the
you
new
check
part
It, check it.
yes because my learned friend's earlier application identical it was dismissed because he hadn't done the underlining now it's done in green but in our copy it was not there
Because
Yes.
the Xerox copy that is
and the deletion is not shown the first this thing should be deleted Tyson Group. That's all. But if your lordship is okay, the name of the plaintiff has not been deleted. Same mistake they've made. They suffered once. It was dismissed for. Let them correct it, and I have no objection.
Lordship will kindly will in that case, Lordship is said.
The
If
name,
pass the order, then the problems will come up.
I understand.
let my
Things will
learned
go
friend make a supplementary affidavit and put the correct.
Kindly give
No,
us leave
no,
to
but-
correct it in the code itself.
Withdraw it. Why can't you check it properly? Take it back. Take it back, file it afresh.
Lordship will kindly give us leave to correct it in the court itself.
There
Lord,
would
in
be a
front of the
problem.
court
As per rules, these should be struck off.
Lord, yes, my lord. Lord, in front of the court officers, my lord, Lordship will kindly give leave to my advocate on record. My lord, it is done, Lord.
No,
Usually
no,
it's
otherwise,
very innocuous,
let him
my lord.
file a supplementary affidavit with a corrected.
It is
I
very
think that would be
proposed.
better.
And then
That
it'll
would be
on
better.
record.
If your lordship kindly allows it, my lord.
Leave is granted to file supplementary affidavit on by the learned counsel for the your plaintiff.
Plaintiff, they are the
Plaintiff. Anything else?
Should not be.
supplementary affidavit to
To our application being
to file the
seven.
proper whatever the proposed amendments, because the order will have to be on the basis of that schedule.
Page 18 it is indicated, the concise statement, but
Come with a supplementary affidavit and check whether anything are yet to be done.
এটা কি violate হবে? Greenটাই তো allowed হয়। Learned friend has the plaintiff, my lord, has made a huge claim. 2021, the name changes, still they haven't taken any steps.
it was noticed when the matter was transferred to commercial division, it was noticed.
It came to the plaintiff's name has changed. Plaintiff came to the
Take it carefully.
But the supplementary affidavit should be served on us before the
Supplementary
indicating
affidavit
the-
shall be served upon the learned counsel for the defendant
Within a week from date.
beforehand.
Hmm.
Let the matter appear in the list on 7 January.
Great.
I'm for the plaintiff respondent. This is an application seeking rejection of plaint.
GA3 is rejection of plaint.
GA4.
What is GA3?
GA3 is for
Disclosure of documents.
Disclosure of documents, my lord. But I have had made my submissions on my application. I had taken leave to file my notes and arguments. It's ready, my lord. I'm filing it today, my lord. My lord was inclined to reserve it for orders, my lord. When I stated that I intend to file a notes and argument, my lord. My written arguments are ready, my lord. I'm filing.
File it. Mr. Ghosh, anything to argue?
Yes, my lord. I have also come with my notes along with the judgments. Your lordship had almost made up your lordship's mind.
File it, I will pass order.
My lord's mind, my lord. These are issues that cannot be decided in Order 7, Rule 11.
Yes, file your notes of argument.
Yes, I'm filing also my notes of argument. These
I'm
issues
not
cannot be decided.
making it reserved.
Yes.
Because if it is possible in the
Your
course of the day,
goes through the notes of arguments of both sides, and my lord keeps it one more day. My lord, if your lordships have.
have you filed notes of arguments?
Yes, now. Yes, my lord. Yes.
Yes, I will pass order then.
Very well. This is not a fit. My lord, I've argued this is not a fit case for Order 7. Rule
All right.
11 is not barred by law. Not here. My learned friend has not shown it's barred by law.
So order only with respect to GA4.
GA4.
Yes.
And then your lordship can take up the GA3
GA3.
after your lordship passes an order.
If it is not rejected.
Yes.
It is not.
Yes. My learned friend smile says it all. My lord.
এই ইয়ে করো তো, আমার তো আরেকটা অর্ডারের জন্য রেখেছিলাম, আমার তো সেটাও ক্যান্সেল হলো। ঠিক আছে, এটাও পাঠিয়ে দেবো।
হ্যাঁ, চিঠি লিখে দিচ্ছি। চিঠি লিখে দিয়েছি।
Item number 6 and 7.
Yes, sir.
But in this matter, it may come back to my lord. On previous occasions, I submitted to my lord that there was a previous suit filed by my client on the same subject matter, for which we have applied, my lord, for releasing.
GA3 and GA4.
These are two applications taken out by them in their suit. That suit is before your lordship. That is a commercial suit. There is another suit filed by us where one of the prayers is similar, where their suit is for eviction. My suit is for administration, as also for a declaration that I am a tenant in respect of the premises. My lord, there were two orders by two coordinate benches which said that perhaps the two suits could be tried together. We made an application to release of the matter. My learned friends insisted on a formal application being moved before the learned judge. We moved a formal application. Elaborate submissions were made. My application was allowed. The suit has been released on the 3rd of December. We have already written a letter to the learned Chief Justice, my lord, for assignment of that suit. So I was praying kindly adjourn this suit for at least 10 days so that, my lord, the assignment comes through and both the matters can be heard together.
My lord,
What is GA2? Let me understand. What is GA3?
GA3, my lord, is my
One suit
application.
is
I
for
applied for the
judgment upon
plaintiff.
admission and one is for order 13.
My lord, today, my lord, there are two applications on board. GA3 is for judgment on admission, both relating to eviction of the defendant. My lord, this is my suit, simplicity for eviction and mean profits. My lord.
GA3 is for judgment on
Order
admission.
12 Rule 6. My lord.
Mine is a prior suit.
Fixing it on the next year, brother.
My lord,
As
will
my lord
kindly
pleases.
one submission, my lord. My lord will fix it on a date for hearing, my lord. My lord will kindly consider one submission. This is my suit for eviction, my lord, which is in pending since 2011. The suit is of
That's okay. But
2011.
so far as
My lord,
order of the
in
Chief
respect-
Justice is concerned,
Yes, my lord, will kindly
that
take on
will
record the
take
order
time.
that's been passed by
So
the
far as
honorable.
I understand.
My lord will kindly take on record the order that's been passed by the learned.
All right.
Well.
There is some sad incident in the family of Chief Justice, so it will take time.
Great.
Adjourn to 10 January.
Grateful.
Really grateful, my lord.
Why are you here?
No, I will be joining my physical.
You are in a car.
Right now, yes, ma'am. I apologize. Great.
All right.
Item number 8.
My lord, in item number 8, my lord, the advocate appearing for the applicant, my lord, is suffering from viral fever, my lord. I am praying for only not this week, my lord.
Adjourn to 17 January.
Grateful. Item 9, my lord, I am appearing for the plaintiff, my lord. This matter has been pending.
What is the status of the suit?
My lord, it has been converted from a regular suit to a commercial
Statements?
suit. My lord, all my statements have been filed, but my lord, from 19th of February, there was a direction on the defendant who has not complied with this steps till date, which is why.
I'm for the defendant, your lordship. I'll just indicate, your lordship, the statement of truth and everything is ready. As and when we send the same to the client for affirmation, then my lord,
1 week time?
my lord,
1 week time?
my lord, there's a difficulty, your lordship. Lordship will kindly.
How long would you take?
Lordship, there has to be an amendment. The name of the defendant company was actually a limited company. Thereafter, during the pendency of the suit, it has now become a private limited company. The new fresh certificate of incorporation has been, my lord, served.
It has been served only on Saturday, which is I was trying to indicate that, my lord. Now this again, this amendment also has to be carried out. If my lord, so
Let this be done first then.
yes, if my lord,
Liberty is given to the learned counsel for the plaintiff to file appropriate application for amendment of plaint in view of change of name of the plaintiff.
only it was a limited company.
My lord,
it became private
from a limited company, it has now become a private limited company, your lordship.
Still then,
I shall take
you have to file amendment application. Suppose a decree is passed.
My lord, I will take steps, my lord.
That is why, lordship, I indicate. Grateful, your lordship.
কবে বললাম date? The suit will appear in the list on 17 January.
Much of it.
Lord, I am for the plaintiff, my lord. On the last option, my lord has directed the registry to submit a report regarding the pendency of the applications, my lord.
I pray for defendant number 2, Lordship.
Who is one?
The suit is proceeding ex parte against one, my lord, defendant number 1. Both the GS are disposed of, my lord.
Report of the learned register. What is the status of the suit?
My lord, discovery inspection needs to be completed and
How long would you take, both of you?
my lord can keep it after the vacation, my lord. In the meantime, we'll exchange the documents, my lord.
Report of the learned register original site dated 7 December 2024 be kept in record. Full stop. The report shows that GA number 1 of 19 and 3 of 23 were disposed of on 6/12/2019 and 17/8/2023 respectively. Full stop. These applications should not appear in the list and their disposal should be noted. Full stop. Next para. As submitted by the learned counsels, discoveries and inspections are yet to be complete. Full stop. The same should be complete on or before the returnable date. The suit will appear in the list on 16 January for framing of issues.
My lord, in the meantime, we'll exchange the suggested
Yes,
issues.
that's there. Suggested issues you can come with here, you can submit here.
Very well.
Even it is not a must.
Item 11. My lord, I appear for the plaintiff, my lord. My lord, the defendant has not been appearing for quite some time. My lord would see from my lord's last order that my
Order
lord
sheet
had
देखिए.
sought a report from the learned registrar, where my lord, it appears that the defendant entered appearance on 10th February 2016 and filed a written statement on 10th May 2016.
Direction was given to cure written
Yes,
statement,
my lord,
cure
it was
defects.
defective. Direction was given to cure them. My lord, we are not aware if that has been cured.
That the report may be called for. A report is hereby called for from the learned register original site as to whether the defects were cured in the written statement in terms of order dated 20th September 2024. The report shall appear in the list. Report shall be submitted before this court on or before the returnable date. Let the suit appear in the list on 7 January.
Section. Item number 12.
My lord, I am for the defendant. My lord, I am being led by my senior, Mr. Bosman.
Is the plaintiff?
My
Is
lord,
it your witness?
No, my
Whose
lord.
witness will be examined?
Their witness.
During the course of the examination, Lordship,
My lord, may I pray for
plaintiff expired, Lordship. They have filed a substitution application, but the substitution has abated. So one more application for setting aside of the abatement.
My lord, may
Delay.
I pray for a short passover, my lord?
H is the substitution application.
When this person died?
August, Lordship. 5th August.
18/10/2000.
No, Lordship, that is the husband. That is the husband of the plaintiff. The husband expired in 2010.
There is an abatement, my lord. They've paid for condonation.
When the plaintiff expired?
Plaintiff expired on August 2024. 5th of
I think that is at page 8 of GA9. Fifth of August.
Look, Mr. Bush, page 8 is a death certificate. There must be something in the pleading that this person died on this and this date.
That is why I said I have to take out I have to file an affidavit. There is no explanation at all.
Apart from explanation, when did he die? When did she die?
It is not there. Your Lordship will not find it.
It is there, Lordship. It is there.
Where mentioned is, tell me, where have you stated the date of death?
GA8. GA8 is the substitution application.
Sir, you have to first move
GA8
GA9
is a substitution
abated.
application, but GA9 is an abatement application. I am hearing abatement.
Your Lordship will find the date at paragraph 4.
Paragraph
4, GA9.
Oh.
Substitution to the
5th August 24.
Yes. Next year is
Proposed amendment of
page 8.
When it is filed?
Lordship, it was filed on 4th of October. Sorry, 4th of November, Lordship, there within time.
No.
After Lordship, due to some defect, Lordship, the matter, it was returned. And it was returned on 8th of October, the last working day.
Anyway, for abundant precaution, this condonation of delay is filed.
Lordship. Lordship.
May I show your Lordship something? Kindly first take GA8. GA8 is not in form.
GA8 is fixed on 6th January. Record has not come.
If GA8 is 6th January, the abatement application has to, because I'll tell you, Lordship, they have completely altered the cost title of the plaint. This is on the original side. You can't have a cost title where the proposed plaintiffs are shown as petitioners. Kindly see the cost title in GA9.
I am fixing a date of hearing. Look, I am fixing a date of hearing. Two separate dates cannot be fixed.
Yes. But keep it on 6th, we'll file affidavit to both.
May I clarify, Lordship, because the copy that has been served upon my learned friend, there was a defect, Lordship, but at the time of filing, it has been corrected.
Then why it is not served?
কোনটা কারেক্ট করা হয়েছে? আরে এটা থাকতে পারে না তো। তো সেটা সার্ভিস করুন। The corrected application
Yes,
itself
that
has not
should
been
be done.
We will serve it. We will serve it.
Adjourned to 6th January 2025 to be heard along with GA8 of numberটা দিয়ে দাও
2024.
GACOM 8 of 2024.
So Lordship is keeping it in January, Malo.
GA8 is fixed on 6th January
এটাও তাই শুনে।
because two applications are same in nature.
Yes.
Okay.
Grateful.
Whether I appear
Or correction.
Yes.
Make corrections, give it to.
It was my lord's pleasure to keep the application pending. That is
Which one?
GA8, my lord. Pleasure pending, my lord, but separately it has been mentioned as GA. Stop, my lord.
My lord, in this matter, my lord, I am appearing on behalf of defendant number 1 to 3, my lord. My lord,
Yes.
My lord, in the second page of the order, my lord.
21 stands disposed of.
My lord, that should not be there, my lord.
Yes, that is corrected. That is should be corrected.
And my lord, the report with regard to GA2 of 2021, my lord, that is required to be corrected. At the
GA8.
second last line of the second page, my lord, GA8 has been written. GA8 of 2021. It should be GA2 of 2021.
এই দুটো correction হবে। All right, order will be passed.
Much obliged.
Lordship, on the last occasion, there was a direction for a report to be submitted by the department. There's a difference in the cost title.
Yes, I've talked to them.
Lordship, which we have already supplied, Your Lordship, by Your Lordship's order dated 19th of June and already corrected the cost title. Probably, Your Lordship, the department did not take into account that correction by Your Lordship's order.
One is spelling mistake, that can be done.
Yes, Your Lordship. And the other, Your Lordship, fresh schedule we have already supplied. We only require Your Lordship's leave to grant to supply the fresh schedule. And 3 has already been done by Your Lordship by order dated 19th of June.
No, look, so far as prayer, have you seen the report? Check it. Come tomorrow, do one thing. Come tomorrow, day after tomorrow, I will make some corrections.
Schedule has been furnished.
Come tomorrow or day after tomorrow.
Very
Not
well,
tomorrow,
Lordship.
day after tomorrow.
Grateful.
Inspection and doctrine appointment.
Or Friday, make it Friday. Thursday is for testamentary matters. Copy of the report. ওই রিপোর্টটা কোথায় দেখি একটু না দেখুন report is submitted by the assistant registrar dated 4/12/24. Full stop. Copy of the report may be inspected by the learned counsel. Let there be inspection. Let the inspect, check and make notes. Let the matter appear in the list on শুক্রবার দিন কত হচ্ছে 13.
Grateful, Lordship.
Three, I am for the plaintiff, my lord. My lord, this is a changed brief and I have not received the vocal
On prayer of the learned counsel for the plaintiff, suit is adjourned to 27 January.
My lord, I am appearing for the plaintiff in this matter. My lord, suit for eviction and mean profit. But my lord, the orders, my lord, which are passed in this matter, the decree has been passed on 27th September 2021. My lord, the defendant, they have, my lord, vacate. My lord, am I audible now? My lord, the defendants.
Raise your voice a little bit.
Yes, my lord, the defendants, they have, my lord, vacated the property, and my lord, the receiver was appointed. The learned receiver was directed, my lord, to break open, my lord, the padlock, and to officially hand over, my lord, the physical, my lord, the possession of the property. My lord, that was done on the 5th of October 2021. The learned receiver has filed a report. On the last occasion, my lord directed the receiver to be present because, my lord, the report, my lord, was not dated, my lord, by the learned receiver. My lord, we have given a notice to the receiver. If I may, my lord, file the affidavit of service.
The learned receiver is not present in the court. When will come? The line ticket is in the like the learned receiver is not present in the court today. The counsel appearing for the learned receiver submitted that presently out of the country and is likely to return in the end of the month. Let the suit appear in the list on 27 January for order.
My lord, one humble prayer.
Under heading to be mentioned.
My lord, one humble prayer. My lord, two applications are appearing, my lord, along with the suit. My lord, with the greatest of respect, my lord, these two, my lord, applications have now become infructuous. My lord, I
come on the next date.
Very obliged.
Item number 5.
I am appearing on behalf of the plaintiffs, Your Lordship. Your Lordships, on the last occasion, was pleased to allow the substitution. Your Lordship, the substitution has been carried out. Now, Your Lordship, we have to serve the parties. Your Lordship, kindly grant.
When did you come?
15 minutes. Just.
Why are you looking at the clock?
No, it was at 10:55.
15 minutes ago, he appeared before me in a car.
No, I was that time parking the car. I could not find a place to park my car, and that by that time the matter was called on. So I didn't want to miss the matter. I appealed.
All right.
Now, Your Lordship, what I am only seeking from Your Lordships today is a leave to obtain the certified copy of the plaint, Your Lordship. That's all. Because then, after obtaining the certified copy,
make an application.
Your Lordship, I am only seeking for leave to obtain certified
Leave is
copy.
granted to apply and obtain certified copy of the plaint. Leave is granted to the learned counsel for the plaintiff. Why leave should be given? It's your right.
Lordship, all I appreciate.
If they apply, they
Your
will.
Lordship, the only thing is what I understood from my learned advocate on record, Your Lordship, that if Your Lordship kindly grants the leave, it will be a more faster process and a convenient.
They can apply for
Your
urgent
Lordship,
xerox
kindly,
That cannot be. If you face any problem, mention it.
Only once this.
That cannot be passed. In every case, I cannot pass order. Then take it out.
Very well, Your Lordship.
Adjourn to 10 January.
Mr. Sinha, you are on mute.
2025 for taking further steps.
Only one thing, my lord. Once they amend the plaint, let them. They will serve us with a copy, and that's the direction also. They will.
That's
serve
the
us
only reason why I'm.
They will serve us with a copy of the
And
amendment.
without let it come, they will serve. If it's not,
yes,
you can mention it.
Great.
If you face any problem in obtaining certified copy, mention it.
Great.
First, let them apply.
Yes.
Number 6 and 7.
My lord, I appear for the
12 shall also come possibly.
Yes, indeed, my lord. Indeed, my lord.
6, 7, and 12.
Indeed, my lord.
Are these connected?
Yes. All these are connected. Well, there is an injunction application filed by the plaintiffs where I'm
Let me understand what is 3, GA3.
GA3 is our application, my lord.
dismissal application, and GA4 is our application, my lord, to extend the time to lodge the writ of summons. So all three have to be heard out together, but possibly my learned friend's application for dismissal has to be taken up first. But the pleadings are not complete.
Just a minute. Restoration of civil suit.
No, my lord. There's no.
GA3 is restoration of civil suit.
Dismissal
106.
of civil suit. Dismissal of civil suit, my lord.
Dismissal of civil suit.
Order dated 14th August 2018 be recalled and the civil suit being CS 106 of 2014 be restored.
My lord, application is filed this year.
This is GA3 of 24.
In
আরে এটা কোনটা দিয়েছো?
এটা দিয়েছো number 241 of 2012, my lord.
তো কজ টাইটেলটা দেখো কি আছে?
Yes, 241. Yes, with the affidavit of petition,
Everything is messed up.
blame it on the weather.
Lord has GA3.
Lodge writ of summons.
Yes, that's my GA4. That's my application.
Yes.
Then GA3 is my current friend's application for dismissal of the suit for non-service of writ of summons. And my lord, GA2 is my application for injunction.
GA3 is by?
GA3 is by my current friends for dismissal of the suit.
By the
For
defendant, my lord.
non-service of writ of summons. Who is affirmed this petition on their behalf? Yes.
Exchange of affidavit is complete.
No, my lord. Kindly take GA2 first. GA2, I am filing the reply today. Kindly, my lord, takes it on record, my lord.
GA2.
Item number 12, GA2. I am filing, this is the injunction application. I am filing the reply today.
GA2 is injunction application.
Yeah, correct. My lord, the interim order was still yesterday. Now, my lord, since my lord, your lordship was not sitting yesterday, kindly extends it, my lord.
You are plaintiff for by plaintiff.
By
Exchange of affidavit is yet to be complete in GA2 of 24, GA3 of 24, and GA4 of 2024. Learned counsel shall exchange their affidavit on or before the returnable date. The suit will appear in the list on 28 January.
My lord, I'm filing the affidavit in opposition to IAGA number 4. Their application.
Just a minute. Ad interim order shall be extended till date. তারপরে লিখো, the learned counsel for the defendant filed
Affidavit in opposition to IAGA number 4.
দাও ওটা।
My lord, since I have not entered appearance in the suit, I'm filing a separate separate affidavit of competency. My lord, the wakalatnama will be filed during the course of the day. My lord kindly gives me the leave to have such wakalatnama filed during the course of the day. For every
affidavit
application,
in opposition filed on behalf of the defendant number 2.
defendants, my lord.
Defendant number 2, shown by defendant number 2.
Sworn by defendant number 2 on behalf of 1 and 3.
Filed by the defendant, filed on behalf of the defendant against GA4 of 24 be kept in record.
Also, my lord, affidavit in reply in GA2 also filed.
Affidavit in reply in GA2 of 24
And my lord,
be kept in record.
affidavit in opposition to GA3 is also filed, my lord.
Affidavit in opposition in GA3 of 24 be also kept in record. আচ্ছা আগে যে দেখলাম এক্সচেঞ্জ অফ এফিডেভিটটা কেটে দাও, ওইটা লিখে তুমি ফার্স্টে যে তিনটে এফিডেভিট বললাম না ওইটা লেখো, তারপরে লেখো exchange of affidavit shall be complete on or before the returnable date. The suit will appear in the list on 28th January. Ad interim order is extended till date.
My lord, my lords, kindly, because I have not filed the wakalatnama in the main suit and the competency in the main suit because of non-service of the writ of summons, I'm having to file a wakalatnama and affidavit of competency individually for each application. My lord, I'm submitting the
Affidavit on competency filed on behalf of the defendant in GA
GA4.
GA4 of 24 be kept in record.
My lord, kindly gives me the liberty to have the Wakalatnama filed during the course of the day, my lord.
Liberty is given to file Wakalatnama to the defendant.
My lord, grateful.
Item 8.
Your
Lordship, item number 8, I am appearing for the plaintiff.
Defendant
Lordship,
number 3, my lord.
Lordship, there are 3 defendants in the suit. This is an application for restoration. Lordship, the defendant number 1 and the defendant number 2, both residing in Dubai, United Arab Emirates, have not yet been successfully served, my lord. Tracking report as on 29th November shows that it is awaiting delivery at the post office. Lordship, I am praying that the
What is IAGA number 3 of 24?
Lordship, IAGA 3 is my application for restoration of the suit.
I am
Lordship,
objecting
candidly,
the application. I am for the
Yes.
defendant number 3.
Lordship, I am not pressing the application now because service is not complete on all the defendants. And Lordship, very candidly, the suit was dismissed in 2018. I am facing over 2000 days delay. I shall have to satisfy my lord on that point. But my lord, since service is not complete, I am humbly praying that the matter be kept
An
after
accommodation is
education.
sought for by the learned counsel for the plaintiff for completion of service of the application, namely GA3 of 24. Leave is granted. Let the suit appear in the list. Let the application appear in the list on 16 January.
I am deeply obliged, my lord.
Grateful, my lord.
Copy shall be served in the meantime.
My lord.
Grateful.
Number 9.
I appear for the plaintiff. Item numbers 9 and 11, well, the parties are more or less the same.
Item number 9?
9 and 11. 11 is, my lord, an extraordinary suit. And 9 is a suit for dissolution of a partnership firm. Now, my lord, in both there are 2 GA applications, GA 11 in item number 9 and GA 1 in item number 11. Both for the same purpose, my lord, similar to the other matter, for appointment of a commissioner to record the evidence of the plaintiff through video conference. I'm the plaintiff through video conference. My lord, here the plaintiff is about 80 years old. He is completely confined to a wheelchair. He had initially come to India way back in 2018 and given his evidence in chief. Largely, it was completed. Only 1 or 2 documents remain to be exhibited. Thereafter, my lord, your lordship will recollect, I had moved this application. Your lordship had called for a report from the registrar IT. There was an earlier order also, my lord, which had been passed directing, my lord, video conferencing evidence to be recorded.
We order to diyo to ager bar agerta jeta korlam.
And well, this is the order that your lordship has passed in the other matter, just last week. Similar set of circumstances here also, my lord, the hardship I have pleaded at paragraphs 20 to 24 that because he is wheelchair bound and he has a pacemaker, my lord, set up, he is unable to travel to India at the moment. He is in UK.
Same order kore diyo.
My lord, only departure will be US. US. My lord, that was in USA. This is in UK. And my lord, a learned advocate can be appointed as commissioner, my lord, with liberty to appoint a remote point coordinator.
Print out diye daw to dekhe kore correction kore debo diye daw.
My submission may be recorded. I am giving objection only. Only recorded, my.
Well, both 9 and 11.
So 9 boleছো.
Chamber diye debe.
May I file the affidavit of service?
This is
Well, affidavit of service.
affidavit of service be kept in record.
Both matters.
বাকিটা আমি দিয়ে দেবো.
I'm grateful. But only one indulgence. But in that one, your lordship has made the returnable date for the report of the commissioner sometime in January. If this can be sometime in February. Only I say this because of his age. I'm grateful.
Item number 10.
8. Deep to.
Who is in 10?
And I'm for the respondent.
Who is the plaintiff? Order sheet dekhi. There is the issue of service of someone, I remember.
I have also asked them for application, but they have not supplied it. My client stays in Israel.
Series of orders were passed earlier.
It was once dismissed for default also.
My lord, for item number 10, the learned advocate who is appearing on behalf of the petitioner, he is on his legs in the other courtroom. So I was praying for a short passover.
Okay.
Item 13.
Look, 13 and 14, I appear for the defendant, my lord. Lord, it's their application GA4, they were moving.
My lord, I appear, my lord, in the next matter. That is item number 14.
What is GA4?
GA4 is an application.
Same application.
No, my, in two suits, my lord, same application for substitution. Actually, my lord, different.
Substitution. Whom will you substitute?
Lord, I'm being led by.
My lord, two of the defendants have died. Kindly see, my lord, defendant number 3 and defendant number 9. Now, my lord, they were.
Naresh Chandra.
Yes.
And Jamshedjul Irani.
My lord.
When the application
When they expired?
GA number 5.
Same parties in both the suits.
Yes, same parties in both the suits. Only one thing, my lord, after this was being taken up, the defendant served us an application being GA number 5.
Yes.
But it's not appearing in the list. But since it's not appearing in the list, my lord, I'm not praying for any directions on affidavits on that score or something has happened there. So far as our application is concerned, my lord, it is of very, in my humble submission, of a very short compass. Once they have died, my lord, we were not initially told that they have died. Kindly come to, my lord, page 54 of the application. It's an order of the court. My lord has asked us a question, my lord, when has they died?
Yes, I've got at least different number 3. Let me find out different number 9.
Yes.
Your Lordship, 31/10/2022.
Defendant number 9 died on 31/10/22. On 27 June 23, the matter was taken up, and then it came to your knowledge that both of them died.
My lord.
And defendant number 3 died on 9 July 2017. Such information was given on 12 September 22.
My lord.
And this application was filed on 16 February 24.
Yes.
Exchange of affidavit is complete in GA 3 and 4.
In 4, my lord. 3, GA4.
GA4 in both the fours.
Yeah, in both the fours.
Both the applications.
Both the applications.
Well, both it's ready for hearing in both. Like my learned friend pointed out, we have taken out an application for dismissal of the for the plaintiff to be struck off because they have not complied with the directions for inspection. That application is to come. My learned friend will probably seek. They have already given us a letter trying to comply with that.
Is that filed?
It's filed, well, it's due to come. So your lordship can treat it on the days list and they can file their affidavits in that and we'll come back. I have lots to say about this, but I'll
let these two suits along with these pending applications appear in the list along with GA5 of 24 on 3rd January.
may it be on the 5th.
5th January.
5th. Great.
This is 13 and 14.
My lord.
Item 15.
Respondent. I do appear for the plaintiff.
What is GA6?
GA6 number. GA6, my application for amendment to my written statement. There's a review pending. So your lordship has adjourned it once on the previous occasion because of the pendency of the review. My Lord Justice Mukherjee is now retired. So a new bench will have to be constituted. So that is taking some time. Kindly adjourns it for allows the comeback after the vacation.
Adjourned to 30th January.
Great.
On prayer of the learned counsel for the
defendant.
The matter is adjourned to 30th January.
Only one point, my lord, I do appear for the plaintiff. Now it's their review which is pending, my lord, on one occasion that has been adjourned. This is the second occasion. If they take steps, my lord, to get the bench constituted.
You also take steps for expedition.
No, of course.
We can also.
16. Your lordship, recall. This is the trust matter which
Hearing is concluded, I think.
Yes, my lord, it's more or less over. Mr. Banerjee.
Notes of argument.
My lord, I appear on behalf of one of the interested persons, my lord, Abhishek Agarwal. My lord, I am being led by Mr. Shakusen in this matter, my lord. My lord, I am afraid, my lord, the arguments more or less have been concluded from their part, my lord, but we have to substantiate a few points.
I had given a reply. Then it would be a reply to reply. I thought Mr. Sen and Mr.
One day I am giving you come with the notes of argument.
That has been given long back.
My lord,
notes of argument are given.
No, my
They're
lord,
just delaying the matter, my lord.
may I,
Just
my lord,
delaying
may
the
I?
matter.
The last occasion, my lord, we have filed our notes of argument. My lord, my senior Mr. Shrikanta Banerjee pointed out that there are certain mistakes in that notes of argument, so that liberty be given to him to take back that note and to file a notes of argument with it. I am filing these notes of argument and we have completed
I am
our
giving a
argument.
short date.
Yes, my lord, kindly appends me.
Come on Friday.
Yes, my lord.
Finish it.
I will come back, my
And
lord.
at any cost, I will reserve it on Friday.
Yes, my lord.
Friday, Friday,
Monday, all right, Monday.
Milord, Friday I'm not there, Milord.
Monday, my lord, we'll substantiate a few points which need to be recapitulated,
Whether
my
you
lord.
do not do or not, I will fix it. I will reserve it.
Be
for
that
order.
as it may, my lord. And my
On
lord,
prayer-
may I?
Note be recorded instead of that note. The note be recorded
Notes of argument is filed
on behalf of Malati Tulsian.
on behalf of Malati Tulsian, be kept in record.
My lord, and I have been requested by one of the parties to file their notes of argument on their behalf, my
Notes
lord.
of argument, all right.
That is Mr. Mahesh Tulsian, my lord.
Notes of argument filed on behalf of Mr. Mahesh can be also be kept in record.
And my lord, notes on
Let the matter appear in the list on 16 December for final hearing.
My
I'm
lord.
extremely grateful, my lord.
Extremely grateful to you.
Grateful to your lordship. My lord. Great.
My lord, the only bit is
Come
our
on
argument.
Monday
Yes,
for final hearing,
yes,
whether you have concluded or not.
fair enough, my lord.
Well, then that would be a reply to reply. Then, my lord, I do not know.
But
that-
be
I
that
need
as it may, my lord.
clarification. I may need clarifications for that. This much.
Whatever my
Grateful. Grateful to you.
grateful, grateful, grateful. Our reply, what we have given. We will not give any
And my
further
lord, the
reply.
petitioner has already filed its note, my lord, long back.
Yes, yes.
I'm extremely grateful, my lord.
Extremely grateful.
Extremely grateful.
Mr. Banerjee,
Yes, my lord.
appear before this court on Monday.
Yes, yes, my lord, I'll definitely be there, my lord. I'll definitely be there. My lord, I mean, court premises on the, my lord, there is a matter going on in courtroom number 11. But I'm really sorry, my lord, I could not be
No issue.
physically
No
present.
issue.
I
No
filed
issue.
that notes on behalf of Mr. Banerjee is there. I filed that notes. Mr. Banerjee has taken a leave for that. That notes will be taken.
Notes of argument is filed.
Yes,
So
they have
grateful,
filed the
sir.
notes on that.
Monday I will reserve it for judgment or order, not judgment, for order.
Grateful,
God
grateful,
bless. Grateful to you.
so grateful, so grateful.
Item 17. I do appear for.
I'm for the plaintiff lordship.
Well, I do appear for the
That
defendant.
rejection of plaint, judgment on admission.
Judgment. Whether that application is maintainable or not, whether there's admission.
I think I have heard you extensively both.
No, my lord has heard my learned friend extensively. I have just commenced my argument. I have given a brief of what is the facts all about.
You are supposed to give some judgments. You have also spent.
I will give. I will
Give the judgments. I will pass order.
He was in the midst of my lord showing some judgment.
No. First, just the facts once, my lord.
Facts I know. Give judgments.
Yes. No. What type to them? What type to them? No. Yes. I have 4 judgments which I would be citing.
And that is not with you right now.
Yes, sir. Yes, it's all with. All with. Chapter is bolo. Yes. Well, chapter. My lord, I will be first relying
So, doctor,
on
give the hard copies of the judgments. I will go through it.
My lord, 2011
And 2015. Give me.
yes. First 2022-10 SCC 496. Yes, ma'am. Volume 10.
This is for you are for defendant.
I am for the defendant numbers 1 and 2.
Which paragraph?
My lord will kindly come to paragraph number. First, my lord, paragraph number 2, my lord. Here the appellant was a tenant. Respondent, paragraph number 3, my lord, will find the respondent landlord entered into a lease agreement, my lord, with the proprietorship consent of the appellant for a period of 24 months. Para 4, first line, my lord will find the appellant did not pay any rent. The para 5, my lord will 5, the appellant defendant filed a written statement containing that after expiry of lease period, respondent plaintiff had approached him and offered to sell the property, right title enter, and there was an agreement for sale of 2017. My lord will kindly come to para 6. In view of the averments made in the written statement filed by the appellant, the respondent plaintiff filed an application under Order 12, Rule 6 on the basis of that averments made in the written statement. Para 7, the contention of the respondent plaintiff before the trial court was that knowing of the admission made with respect to the landlord-tenant relationship and of the rate of rent and defense taken by the
Next
appellant.
one. I have seen.
My lord, just my lord, only the point which is a
point which you are supposed to say
is
supposed to be
23,
from 20
23
onwards.
23 and 24.
Yes, I've seen that. Next one.
And the most important
Next
part
judgment.
Yes, ma'am.
I've seen that.
2010, Volume 6, SCC, page 601.
Which paragraph?
Yes, madam. 2010, Volume 6, page. Jeevan Diesels. This para 2 is all the facts, my lords. Then my lord will kind to para 11. 11 is Uttam Singh Duggal has been referred to. And para 20.
Yes. Para 20 is only conclusion.
Conclusion.
Next.
Only para 11, my lord.
Yes, I've seen. Next.
Then my lord will come to para 2015 volume 9 SCC 287. Whether the defense goes to the root of the matter.
Have you got Mr. Huda? Which paragraph?
This one. 15 volume 9.
Para 8.
This para
8.
8, my lord. 9, 8, 9. 8 and 9. Is it? Judgment of admission is not a matter of right, rather is a matter of discretion of the court. And where
Any reply, Mr. Huda?
One more judgment, which go to the root of the case. And another.
He will continue. He will not stop.
2011, volume 15.
Which paragraph you're referring to?
Volume 15. This
one. 11.
Yes, madam. Volume 15, para 11. It is true that a judgment can be given on admission contained in the minutes of meeting, but the admission should be categorical. It should
Yes,
be
I've got it. Mr. Huda, any reply? Any reply?
Yes, my lord. There are 5 points.
Have you filed notes of argument?
No, we've not, my lord. We will. Lordship has not directed yet because the.
Come on the next step.
A very short reply, my lord. Will not take much time. Will not take much time. 5 points he's taken, my lord. First point, my lord, he has shown page 21, my lord, to show that at the time when I had obtained the degree, my lord, the person's named, my lord, in that degree are different than the person's name, my lord, here in this suit, my lord. To this I say, my lord, that degree that was passed, my lord, was not against any person, was against a partnership firm. The partners of a partnership firm will come and go, my lord. But the partnership firm remains. If there is change in the my lord, the constitution of the partnership firm, that does not mean, my lord, that the partnership vanishes, my lord. My degree was against the partnership firm. I have obtained a degree, my lord. He comes and says that I am a partner of that partnership firm. Therefore, I should be allowed to stay in this validity. So I already have a degree, my lord. Second, my lord, he had shown page 21 to show, my lord, that in that degree that I had obtained, in the schedule, it was written a shop room. But in my schedule, it's written as a go down, my lord. It was being used as a shop room by the erstwhile occupants in the year 1990, my lord. Now I have been using it as a go down after getting the degree. It is, my lord, it is my right, it is my property. I can use the property the way I want to.
All right.
Third, my lord, he has shown, my lord, the boundaries at page 22 of my application to show, my lord, that the boundaries are different, my lord. My lord, the premises number, my lord, he is not disputing. There's just one space that he is in possession of. As he says, he's a
come with it. This is a factual aspect. Come with the notes of argument. Monday.
Notes of argument. Well,
Monday.
I will also file a notes of argument, man.
Monday is okay.
Yes, Monday is okay. But may I, in the meantime, I just distinguish the judgments that he cited?
Monday is okay or not?
Wednesday, my lord. Wednesday, my lord. I'll come.
Hard in part adjourned to Wednesday is 18th December.
19th.
Stop. The
Well,
learned
19th.
counsels are at liberty to file notes of argument.
19th, my lord.
You annex it with the notes of argument.
If your lordship so wishes, I'm in a position to dispute these judgments right now.
Come on the next day because I cannot remember. That's why I am requesting you to make a notes of argument.
I will bring a notes of argument.
Item 18. Item number 18. Should I beg to appear for the defendant?
Sir, I'm appearing for the plaintiff, my lord. Now, this is my application for transfer, my lord, from the ordinary original jurisdiction to the commercial division, my lord. My lord, on the last occasion, lordship
May I
was
file the, my lord, opposition, my lord?
that we received the opposition only yesterday, my lord. On the last occasion, my lord had
Reply?
expressed that it would be transferred.
Reply, Devi?
When the suit was filed?
The suit was filed, my lord, as per our records on 17th of July 2018. And my lord, I have relied upon the notifications from page 28 onwards. My lord, this is admittedly a commercial suit, my lord, because it involves a commercial construction contract in terms of section 2E, my lord, of the Commercial Courts Act. I am a subcontractor, my lord. Work order was there, agreement is there, my lord. Work has been done, money has not been paid. There is no dispute as to the nature of the work done. The only dispute is pertaining to the notifications. At page 28 onwards, my lord, if lordship kindly takes up my application, that I have relied upon, my lord, the notification for constitution of Commercial Appellate Division of the Calcutta High Court and Commercial Division of Calcutta High Court. That is dated 16th July 2016. Now, my lord, although the act was promulgated in December 2015, my lord, it became operative in West Bengal only under these notifications. So, my lord, it came on 16th of July 2016. It was established in terms of section 4 of the Commercial Courts Act. And, my lord, at page 29, my lord, I have relied upon a notification of 15th November 2018, my lord, which sets out the specified value. That kindly comes to page 29. My lord, in terms of section 3, subsection 1A, which was subsequently amended, my lord, it was imperative that a specified value be notified under the act to determine the value of the suit which shall be filed before the Commercial Courts Act, my lord. As per this notification, the specified value was only notified on 15 November 2018. There is a judgment of this honorable court, my lord, Lakshmi Polyfab, my lord. It's a settled law, my lord. As per that judgment, my lord, it was already decided, my lord. This issue was exclusively dealt with. Yes, ma'am. I'll just give you a call. My lord,
Yes, what do you have to say?
Lord, kindly comes to the Lord. I shall deal with this Lord judgment later on. Lord, first, Lord, let us come on facts. Lord, what is the application targeted at? Lord, suit filed on 17th of July 2018. Lord, kindly comes to the notification at page 28. So, Lord, as per their admitted case, the commercial court was established back in 2016, much prior to filing of the suit. Admitted case. Now, my lord, the second aspect, my lord, had there been no situation of, my lord, section 12A, my lord, then your lordship could have transferred, my lord, things would have been different. But section 12A was incorporated by the legislature on 3rd of May, my lord, 2018. And my lord, there was no, my lord, exception carved out in the legislature while amending that until and unless, my lord, the mechanism is set forth, my lord, the leave won't be required. Lord, as on date, Lord, we are sanguine. We know it's sacrosanct that, Lord, section 12A leave.
Have you gone through partial automation?
My lord.
Have you gone through partial automation?
Lord, this partial automation is here. Lord, I shall deal with. That's why I said, Lord, I'll deal with.
What time frame is given there? There is a time frame.
Yes. Lord, 72 onwards, this judgment, Lord, my learned friend, Lakshmi Polyfab. Section paragraph 72.
Go through that. Partial automation. Have you got that?
Lord, Lakshmi Polyfab is, Lord, affirming, Lord, following partial automation.
What is in partial automation? Unless mediation center is set up.
Yes.
When the mediation center was set
Lord,
up?
unless mediation centers are set up, in that case, Lord, section 12A leave will be asked on mere asking.
But plain shall not be rejected.
Plain shall not be rejected. But the leave has to be there. Until and unless leave is granted, Lord, it does not render, Lord, partial automation does not render the provision of section 12A ratio. It does not say 12A won't be required.
It
When the
says,
suit was instituted,
Lord, much after Lord, the incorporation of 12A. 12A was incorporated on 3rd of May 2018
with effect
and
from
suit filed it. Yes, Lord, with effect from that itself. I shall come to notification also. Commercial court sector.
নোটিফিকেশনটা কবে হয়েছে? সুট পেপার আগে হয়েছে। Look, may I just take 1 minute? Very simple matter.
Let him submit.
What comes first, the notification or the suit? At the end of
Lord,
the
the
matter.
first come
If notification আগে হলে suit হবে না transfer।
কথা বলছো।
দেখো, when suit is filed, act was in vogue. Act may be in vogue, but Patil and Lakshmi in both judgments, Lakshmi was affirmed impliedly in Patil. The notification of specified value has to come. Notification of specified value, Milord, has come, page 29, 15th November 2018.
Wait.
By that time, suit was filed. Milord,
before that time, prior to that.
before that time, suit was filed. So there is no problem. Now, if my learned friend shows me, Lord, that notification happened before the suit was filed, and there's any prior notification, that's the end of the matter.
Now, Lord, if my learned senior friend has concluded, Lord, then if I may, Lord, what does this notification at page 29 say? Lord, initially, your Lordship would recall the valuation, the specified value was, Lord, for 1 crore. Subsequently, it was, Lord, watered down for 3 lakhs to original side and, Lord, 30
But it
lakhs
is more
to the
than 1
district.
crore.
This suit was admittedly 1.5 crores. So under no Lord, situation, the specified values notification could have affected this suit. Lord, kindly.
Mr. Chaudhary's submission is the suit was filed at the time when the specified value was not notified.
Yes. My Lord, point is that the specified values amendment did not trouble this suit at all. Because in any event, the suit was valued at 1.5 crores. Kindly comes to the plaint once.
Yes, that I've seen.
Yes. So, my lord, whether the specified value changes or not, how does my learned senior friend suit gets affected on that?
All right. Have you filed any? Would you file any judgment?
Just draw your lordship's attention to section 3 of the Commercial Courts Act.
Yes.
The lordship will not see this issue once. The section is very important. Section 1, capital A, my lord, which comes in on 3rd May 2018. First, my lord, let me read the section. State government may, after consultation with the concerned High Court by notification, constitute such number of commercial courts, etc., for the purpose of exercising jurisdiction, provided that with respect to High Courts having ordinary original civil jurisdiction, state government, after consultation by notification, constitute commercial courts at district judge level. Then, my lord, kindly see provided further that with respect to a territory over which High Courts have ordinary original civil jurisdiction, the state government may by notification specify such pecuniary value which shall not be less than 3 lakhs and not more than pecuniary jurisdiction. Then 1A, notwithstanding anything contained in this act, the state government may, after consultation with the concerned High Court, by notification specify such pecuniary value which shall not be less than 3 lakhs or higher for whole or part of the state as it may consider necessary. State government shall, after consultation with the concerned High Court, specify by notification local limits, etc., etc. Now, my lord, the notification comes on 16th of July 2016 at page 28. The commercial appellate division is constituted.
The constitution of the commercial court was much prior to the filing of the suit. That's an admitted case.
The next page, my lord, is the
page 4. That is commercial division.
Page 28.
Sorry. Section 4. That is Constitution of Commercial Division.
Yes. Now, my lord, the notification comes, my lord, at page 28. That I just noticed. It's done by your lordship. This is not the Commercial Appellate Division.
My lord is the author.
Then, my lord, next page, my lord, page 29. In exercise, this is 15 November 2018. In exercise of past
And you are making that submission to me.
Lord, that's why I am more not confident in making this submission.
Lordship would know best, having constituted it. Exercise of powers conferred by subsection 1A of section 3 of the Commercial Courts, Commercial Division and Commercial Appellate Division. The Governor, after consultation with the High Court, is pleased to hereby specify the pecuniary jurisdiction in respect of the value of the commercial disputes of.
So after institution of this suit, this notification was published according to you.
Lord,
All right, I'll pass on.
Lord, my submission to this is, Lord, even if this notification
Have you
was
looked qualified?
Yes, Lord, Lakshmi qualified. Lord, even if, Lord, that notification, this notification was subsequent.
Let's see
Lord,
paragraph
that
17.
That
please.
did
71.
71. Lord, I'll grant me to Lord some time, Lord, to reply to Lord my
Section 71, section 15.
All right, then both come with your notes of argument.
Very.
We'll do that, my lord. And also, my lord, I'll put my learned friend on notice.
Mr. Chaudhary, I will not mark it because if you
I'll
come in the
annex
note,
it to the note.
oh, yes, annex it.
Lord, before my learned senior friend says also, Lord, practice directions will not apply in this case at all.
Very well. Also, my lord, paragraph.
Are in part, the learned counsels are at liberty to file notes of argument. Let the matter appear in the list on today's
Lord,
10th,
10.
16th December.
Lord, the affidavit of opposition, Lord, made.
Affidavit in opposition be kept in record.
Very clear, my lord, paragraph 71.
Lord, I shall deal with in my
court. I'll also find out if my learned friend, my lord, Lord, if his arguments are correct, in which case I will concede, but then I think it is not so. Lord, I'll check up myself. Point of law, there is
Yes,
no
yes,
dispute.
absolutely a point.
It would.
I am for the defendant number 2, my lord.
My lord, I am for the plaintiff, my lord.
The written it was filed on, my lord. According to me, my lord, it was filed on 7th of November, my lord, within
My
time.
lord, on the last occasion, my lord has directed the department to file a report or to see
Then-
whether the written statement has been filed in the
Within
department.
time. It was extended up to 4th of December, my lord.
Report of the learned register original site dated 7 December 2024 be kept in record. Full stop. Written statement has already been filed on 11/11/24
By defendant number 2, my lord.
by the defendant number
2.
2. What about defendant number 1?
Defendant number 1 is not required because the Union of India through secretary. Defendant number 2 is the answering defendant. Defendant number 2 was the lessee, my lord. This was a lease agreement. Award was passed. They have come for mean profit.
Discoveries, inspections, and disclosure of documents shall be carried out on or before the returnable date. Let the suit appear in the list on 17 January under heading for framing of issues.
Grateful with it.
Number 20.
But I am for the plaintiff, my lord. In this matter, my lord, the special referee appointed, but report not it been filed, my lord.
I am for the respondent number 2.
Who is the special referee?
Promise from the court, my lord, by an order dated
27 September 2024.
The learned special referee is to be present in the court on the returnable date with the report. Let the matter appear in the list on 24th January. Copy of this order may be communicated to the learned special referee.
Then 21, my lord, I to appear for the plaintiff on the task on the my lord has been pleased to fix this matter for witness action. This is a matter, my lord, which was pertaining to for fixation of that mean profit, my lord. My lord was of the view that till that determination whether they are in wrongful possession or not, my lord, the mean profit.
Mr. Dashgupta?
Yes, my lord, firstly, my lord, this will be a commercial court because your lordship can see order dated 7th May.
Yes, that.
The second page, last paragraph.
ট্রান্সফার হয়েছে দেখো তো। Yes, it is transferred.
Well, it is appearing in the
ordinary
list.
In terms of order dated 7th May 2024, suit was directed to be transferred to commercial division and department was directed to take necessary steps. Although the suit was transferred, neither the suit is numbered nor the suit is appearing in the list of commercial division. Full stop. The Learned Register Commercial Courts Act, commercial division, কি বলে ওটাকে ডেজিগনেশনটা? The Learned Register Commercial shall take necessary steps in this regard. Copy of this order may be sent to the Learned Register Commercial.
Only liberty be given to the learned advocate for the plaintiff to take, complete all the formalities once it's transferred. The learned
Let the report come. Let these things be done. Let the suit appear in the list on 3rd January for further order.
My lord, I am appearing for the
Issues are there. Have you filed issues? I'm making me not today. Today I have a lot of other matters. I will frame tomorrow. Tomorrow I will frame issues. It will come on the list tomorrow. Let the issues be kept in the record. Tomorrow I will frame it. আচ্ছা নিয়ে নাও, আমি ইস্যু ফ্রেম করে দেবো, হয়ে যাবে।
I'm grateful. My lord, grateful.
Our date will be fixed for
Yes.
witness action. Is it a commercial matter?
No, my lord.
So that will be in the month of January.
Yes, but my lord, on or before 20th January, my lord. Because
After 20th January. All right.
After 20th.
But we will start our evidence.
No.
He can be
After
there.
20th January, my lord. My client, the question of the evidence is also.
All right.
I'm grateful.
23. Who is the plaintiff? You are plaintiff. Yes. Undefended suit. Witness is there.
Your
That is brief.
Lordship, this is an undefended suit. Kindly keep the matter after the vacation for witness action.
On prayer of the judge's brief.
No, Your Lordship, because of that only, because the documents are being
On prayer of the
reconciled.
learned counsel for the plaintiff, suit is adjourned to 30th January.
Thank you, Your Lordship. Grateful.
Don't say thank you.
24. My lord, I appear for the plaintiff. My lord, this was to be marked as an undefended suit today. My lord, however, in the meantime, my lord, the clients have asked to withdraw the suit.
Then file something.
I have a letter, man.
Learned counsel for the plaintiff files a copy of instruction received from the plaintiff and submitted that the suit, recorded language, the suit may be withdrawn. Make a signature here. Just attest it. Let the suit be dismissed as withdrawn. Disposed of as withdrawn. Not this week করে দাও. Passover not this week.
My lord, kindly not do that, my lord. This Passover matter is item number 10. I wish to move an injunction application. This matter has been...
Have you filed it?
Yes, my lord, it's pending. There was two times substitution. The last defendant who has been substituted has been served, but they are not appearing. On an inquiry from the department, they said that they have not even filed the Vogalatnama. Affidavit of service filed before your lordship.
Come tomorrow.
My lord, kindly keep it tomorrow.
Not today. Making it not today.
আমি অ্যাপ্লাই করেছি নামই নেই
arguments. Lord, may I only request, if it's convenient, my lord, your lordship can give me a 10-15 minute passover. Mr. Mitro, he's on legs in another, in Justice before Justice Mantha. He'll come in 15 minutes. I'm told, my lord, there is a witness action that can go on for 15 minutes or so, and then Mr. Mitro can come and take over the next matter, my lord. I've requested, sir. I've already requested, sir. I've already requested.
Lordship, praying for leave to mention item 30 and 31. I'm being led by Miss Noel Banerjee in this matter.
Lord, I am appearing online, my lord. I am praying for one accommodation for today, my lord. Kindly takes it up tomorrow. I am actually not there. No, I'll inform the other side, my lord.
26.
I pay for the defendant, my lord.
The witness has come, my lord.
Well, yes, come, you are here. Blue shirt, black shirt, light blue shirt. Okay. All of PW1. Cheap. May I start? Yes. First rate. বাংলাতে ইংলিশে তো মিলিয়ে
আমি যেটা বলছি
হ্যাঁ।
সাথে সাথে আপনি I solemnly affirm whatever I depose by the way of evidence I shall speak truth. I shall speak true. No part of it shall be false. And I shall not conceal anything. I shall not conceal anything. Your name? My name is Miraj Rashid. MERAJ RASHID. Father's name? Harun Rashid, late Harun Rashid. HARUN Rashid RASHID. Age? My age is 52. Occupation? I'm a businessman. Residential address? 8 AK Muhammad Siddiq Lane. AK Siddiq Lane, Kolkata 7,16,16.
Yes, sir. Your name, please.
My name is Miraj Rashid.
How are you connected with the suit?
I am a plaintiff in this suit.
Your occupation, please.
I am a businessman. আমার একটা কমার্শিয়াল স্পেস আছে, স্পেস ফ্ল্যাট নম্বর 117, ফার্স্ট ফ্লোর, on 23 Marquis Street, Kolkata 7,16,000, consisting of 18 rooms for guest house.
Are you owner of the said commercial space?
Yes, I am the owner of that commercial space.
Do you pay the municipal corporation tax after mutating your name?
Yes.
Are all leading. These are leading. Do you pay? This will be answered in yes or no. After mutation, as well as yes, madam. Yes. What purpose you use that premises?
I use that premises as a commercial purpose, as a guest house.
Do you use for his own purpose or for rent purpose?
First of all, I was not in good financial condition, so I tried to rent it out. Condition, so I want to give on lease basis. I give on license fee, on a license fee basis.
May I show you one document?
It's my Miraj Rashid, sir.
This room council properties are in the name of your name.
Yes, my lord.
Yes. I'm showing you one document. Kindly tell my lord, what is this document about?
My lord, this is the corporation property tax bill. Property tax bill.
Disclose document, my lord. Is this the corporation tax receipt?
Yes.
About the premises number 23 Marquis Street and flat number 117.
It is
As-
completely leading.
Yes.
It is not. As you look. As you look. Mr. Rashid, why have you filed this suit?
Just tell me, first tell this court, who is the defendant, how you are related to
My lord, once this Mr. Muhammad Nasim have came to me, Nasim came to me, my place আমার আমার ঘরটা এরকম খালি পড়েছিল। তারপরে উনি কোনো রিলায়েবল সোর্স থেকে খবর পেলেন যে এটা উনি নিতে চাইছেন।
That he has got a news from a reliable source that he that the housing is vacant condition.
was lying vacant the guest house.
We want to
Mohammed Nasim got information that the room was lying vacant. Full stop. He approached me for letting it out to him.
Yes, my lord. ঠিক। এটা হয়েছিল মার্চ 2013-তে। ও আমার সঙ্গে এসে কথাবার্তা বলেছিল।
We had negotiation in the month of March
13.
Pursuant to the approach made by Muhammad Nasim,
মাই লর্ড, ওনার সঙ্গে আমি কথাবার্তা বলে ওনার সঙ্গে একটা লিভ অ্যান্ড লাইসেন্সের জন্য আমরা সেটেলডে গেলাম।
the negotiation we have made a agreement.
লিভ অ্যান্ড লাইসেন্স
We made a
which room?
ফ্ল্যাট নাম্বার 117, ফার্স্ট ফ্লোর, 23 মার্কো স্ট্রিট, ক্যালকাটা 7,16,000, ফার্স্ট ফ্লোর।
the flat consisting of how many rooms?
18 রুমস, কিন্তু ওনার সঙ্গে আমার 15 এপ্রিলে একটা লিভ অ্যান্ড লাইসেন্স হলো, তার মধ্যে আমরা 16টা রুম দেবার ওনার সঙ্গে কথাবার্তা আমরা বলেছিলাম। তার মধ্যে
There are 18 rooms, but we have an agreement on
16 rooms, my lord.
room of rent.
হ্যাঁ,
For that we have made.
I rented
agreement.
Later to Mohammed Nasim.
Nasim.
To the defendant.
The defendant.
After that we have made an agreement on 15 April 2013
15 April 2013.
and we have sent out the room, 16 number of room to Mr.
Muhammad Nasim.
Muhammad Nasim.
you have made an agreement with Mohammed Nasim for how many months
আমি
to occupy this 8 commercial space?
আমি মোহাম্মদ নাসিমের সঙ্গে 60 মান্থের এগ্রিমেন্ট করেছিলাম। দ্য এগ্রিমেন্ট স্টার্ট ফ্রম 1st January 2014 till 31st December 2018, my lord.
Have made the agreement for 16 months. Agreement was executed for 16 months, and it was started from 1st January 2016.
My lord, I'm sorry, 60
months, my lord. 60 months.
It was started from 1st January. Starting from 1st January 2014 to 31st December
2018.
What was the occupation charge or license fee for each month?
The occupancy charge was 2,20,000 per month. 20,000 per month. ও ছাড়াও হোটেলে যেসব লাইসেন্স, পুলিশ লাইসেন্স, ট্রেড লাইসেন্স, ফায়ার লাইসেন্সের যা এই পিরিয়ড মানে ওই যে টাইম পিরিয়ডটা দেওয়া ছিল ওর মধ্যে যে লাইসেন্সের ফি গুলো হবে সেটা ও দেবে। আর
from these all the license fee like commercial কি বলুন,
ট্রেড লাইসেন্স, পুলিশ লাইসেন্স, ফায়ার লাইসেন্স এক্সেট্রা যেসব লাগে।
from the apart from rental amount, all incidental license fees were payable by Mohammed Nasim.
ও ছাড়া বিল্ডিং এর একটা মেইনটেনেন্স চার্জ হয় মাই লর্ড, তার মধ্যে 50% ও দেবার কথা ছিল অ্যাজ পার এগ্রিমেন্টে।
50% of the maintenance charge was to be borne by
I'm showing you one document. Kindly tell my lord, what is this document about?
মাই লর্ড এটাই হচ্ছে ওই লিভ অ্যান্ড লাইসেন্সের এগ্রিমেন্ট।
Actually, the lease and license agreement.
Leave and license.
Leave and license agreement. Encircle your signatures.
When this agreement was executed,
Signatures.
when this agreement was executed,
এগ্রিমেন্টটা হয়েছিল লিভ অ্যান্ড লাইসেন্সের এগ্রিমেন্টটা হয়েছিল 1st January 2014।
when it was executed,
আচ্ছা ওইটা হয়েছিল 15 এপ্রিল।
you go through this and tell my lord.
15 এপ্রিল 2013।
Was this agreement was executed by you and the defendant by putting your signatures?
ইয়েস, আমরা দুজনেই সিগনেচার করেছিলাম।
Kindly tell my lord, where both you and Mohammad Nasim put your signature and Mr. Nasim also put his signature.
লিভেন লাইসেন্সের মধ্যে মাই লর্ড দুজনের সিগনেচার আছে।
My lord, both the signatures, my lord. Yes, my lord. My lord, defendant has also put the signature by executed. Yes, my lord. As you like. May I tender this document, my lord? As well. After the agreement was executed, what happened with regard to the leave and license agreement and so far the occupation of the commercial space?
কি বলছেন? ওর সঙ্গে একটা আমার কথা হয়েছিল, রিনোভেশন চার্জ লাগবে।
We have made an agreement about the renovation charge.
That is on page number.
You go through this and tell me.
That is on page number 13. Menu of consideration. Memo of consideration.
Kindly tell my lord, in terms of the agreement, what you required to do and what Mohammad Nasim was also required to do. আমি বাংলায় বলে দিই। As well.
Just picking it up and on the way of execution. Next one.
Mom.
Take the paper. How long will you take?
Half an hour. Half an hour.
How long will you take the next step?
Next time, my lord,
January. আর এই বিফোর ভেকেশন আর কিছু থাকবে
next week, my lord, any day.
ঠিক আছে।
My lord, I will come.
It is commercial. I have a commercial transfer for all. It is commercial. May I check and Lordship, I shall. Lordship.
Item 25.
ধরে নিচ্ছি, তুমি বলো দাও। মাত্র 2 মিনিট।
I'm grateful to my Lord for kind accommodation provided. But the code issue, and I'll just cite few cases, is whether that we have the right to use the said compound or courtyard for keeping cars while being delivered to the client in course of delivery. Not on, we have established, according to our humble submission, that right on 3 pillars, if I may use the expression. First is long use of the courtyard for this purpose, and clearly enforcing my right without any objection, without a knowledge. what is this is a right made by judgments of the court. It's in my humble submission is well settled. A judgment on this point, may I cite one or two how the long prior use affects. My lord,
Compilation of judgment করা হয়েছে।
compilation of judgment. Yes, we have made it. Yes. Oh, loose করা আছে এখনো? এখানে দিয়ে। But I gave you lordship the judgment. For the time being, we have site. It starts from yes. With index indicating topic keywords, keynotes. 7 Indian appeals, for example. Dear doctors, 7 Indian appeals, for example. This is for the proposition that in this case, there's a use for 20 years. Use of the right of way for 20 years. From that, Privy Council said more than 20 years, long user, more than 20 years, presume grant or an agreement and without the aid of Limitation Act. And Limitation Act not required. Lordship, at page 246 to 248. 7 Indian appeals, 240, at page 246. 240 and 246. আমার বুঝতে আছে আমার বইগুলো এনেছে কি জিজ্ঞেস করছো বই কেন 246 minute. Kindly minute come to page কত দিয়েছো? Page 246. এটা ইন্ডিয়ান অ্যাপিলস দাম না,
এটা ইন্ডিয়ান অ্যাপিল জি যখন প্রিন্ট বেরোয় ওরা এইখানে পেজটা দিয়ে দেয় কোথা থেকে শুরু।
246 minute.
Internal page 6.
Internal page 6. Paragraph starts, their lordships were disposed to dissent from the view of the High Court and to come to the conclusion the subordinate judge really did intend to. No,
Internal page 6. On the top, my lord, your lordship will find the internal page is referred to SCC online. Internal page 6. And in the middle of the page, your lordship will find with a dotted line, there is a 246 written under the dotted line.
Yes. No.
Their lordship.
Yeah, their lordship are disposed to dissent from the view taken by the High Court and come to the conclusion subordinate judge really did intend to do something that existed. Very obstruction. Had existed, assuming the fact to be the Munshi and the right court have regarded, namely that this obstruction has existed for more than 2, but for less than 20 years. They think that no provision of a limitation statute interferes with plaintiff's right. The Limitation Act 1971 contains 2 sets of provisions which are in their nature distinct. One relates to the limitation of suits and prescribes the limitation of time for bringing suits after the right to sue has arisen. Others set relates to the manner of acquiring title and rights by possession and enjoyment. The latter provisions are contained in Part 4 of the Act. Now section 25, which is section 25. If I may continue reading, and please now come to turn the page, immediately consider. Please come to page 247, second part, conclusion. At page, at
internal page 8, my lord.
8,
Internal
page 8. this being an artificial pine constructed on the land of another man at the distant period found by the court and enjoyed ever since, or at least down to the time of the obstruction complained of by the plaintiff and his ancestors. Any court which had to deal with the subject might and indeed ought to refer to such a long enjoyment to a legal origin, and under the circumstances which have been indicated, to presume a grant or an agreement between those who are owners of the plaintiff, Mahai, and the defendant's land by which the right was created. That being so, the plaintiff does not require the aid of statute and his right limitation statute, therefore is not in any way, any degree interfered with by the provisions in the 27th section of the Act. The 27th section of the Municipal Limitation Act is now 25, old Act. So without taking aid of Limitation Act, this is the portion, my lord. Long use of more than 20 years in this case lead to the indicate presumed ground. That's what we call implied ground, my lord. Next judgment. Next, it has been considered, my lord. Next, then AIR 1922 Madras, page 5. At page 6, my lord, right hand column. It is copy too. At page 6, right hand column. The middle, report witness examine, forget that. There is no suggestion of any license given, but there is no suggestion, right hand column. I am reading third paragraph. There is no suggestion that any license given by the defendants or their predecessors claim titled of scavenger cleaning plaintiff's privy by entering through their house. In the case of a long enjoyment of right claim, a legal origin should be observed by Lord Herschel in Phyllis versus circumstance. Should as observed. I am corrected, my lord. As be presumed, when there has been long continued user of a right, if such a legal origin were possible, and the court will presume that those acts were done and those circumstances existed which were necessary to creation of valid title. The presumption of a lost grant in such cases has been recognized in leading case Goodman versus Circumstance, military English judgment, appeal case, House of Lords, circumstance, however, should exist. The circumstances should, however, exist, which would render the drawing of the presumption reasonable. In fact, but as pointed out by Justice Farwell in such and such case, not only would courts be slow to draw the inference of facts which would defeat a legal right which has been exercised for a very long period, unless such interference is irresistible, but will presume everything that is reasonable, possible to presume in favor of such a right. Well, user is proved. The presumption is that it is a right, it is of right till the contrary is proved. Gale, in his valuable treatise on easement, has said this, quoted below, effect of user would be destroyed if we are shown that it took place by exercise of express presumption, etc. Next paragraph, my lord, I tell you case is very peculiar case, my lord. In this case, the defendant was having the privy. Scavenger used to go. Next judgment, my lord. Please come to my Calcutta High Court judgment now. Here 1920 Calcutta 363 and 61. Now, now. Good. Page 362 to 63. User of a right which does not form part of the tenancy agreement was uninterrupted period of 12 years, established a lost grant right of way. This keyword. Chief Justice Acting Justice Mukherjee and Justice Fletcher. Now, please come to me, Lord, the page 362, middle paragraph. The subordinate judge found that plaintiff and their predecessor had exercised a right of way for over 60 years. Our case, 53 years. Though there had been an interruption of the right for 10 or 12 years. And he concluded there must have been a lost grant. Mr. Mitter, on behalf of defendant respondent, has argued that the inference was one of law and that it was consequently open to this court on second appeal to take a different view from that adopted by the Court of Appeal below. We are unable to accept this contention as well founded. The gist of the principle upon which a lost grant is presumed is that the state of affairs is otherwise unexplained. Justice Farwell, same judgment, my lord, said, when the court finds an open and uninterrupted enjoyment of property for a long period unexplained, omnia presumptor, etc., and the court will, if reasonably possible, find a lawful origin for the right in question. The process is one of inference of fact and not of legal conclusion is well established. We need refer only to observation of Lord Justice Brett in Angus versus Dalton, where he stated that question in controversy was whether the inference was to be treated as a necessary legal consequence or as an inference of fact. This was said with regard to what had happened in the decision cited during argument of that case, which fell into two classes. In one class of cases, it was stated that if user for 20 years was established, the jury could be directed as a matter of law to hold that a lost grant had been made out. In the other class of cases, it has been held that the jury were free to draw an inference to that effect if evidence was not rebutted. Then Justice Brett added that if the case was tried before a judge without a jury, he must find such facts, though he might not do so in terms if already. This is not our Calcutta High Court division bench. Next judgment, my lord, you kindly see another Calcutta High Court judgment, year 1933, Calcutta 215, at page 216 and 7. This is judgment of Justice Mitter, sitting singly. If you kindly come to my lord, page 216. There is no paragraph number, but you can ask it. 216. The pleadings in India have to be somewhat
Paragraph 3, my lord. Paragraph 3.
3. Pleadings in India. It's come to me, lord, this end of this, last 4 lines of that paragraph, it seems somewhat singular. It means somewhat singular that the words
4 lines from
immemorial user.
4 lines from paragraph 3, if your lordship sees on the right, it seems to be
Pleadings have been in India, pleadings have to be considered somewhat liberally, notwithstanding the fact that lawyers in general, in the commercial now, fully.
Seems to me that although this
Lordship of Privy Judicial Committee.
Yes, my lord.
No, actually, last 4 lines it may lead. No. It seems somewhat singular that words immemorial user were not used, although facts were alleged to convey convey the impression that the plaint was founded on the case of immemorial user. It is difficult in the facts of the case of Mahadani Rajwa, etc., one that is 37 Indian appeals which I have cited, to say that the defendant should be given a further opportunity of meeting the case of immemorial use, seeing that the plaintiff did allege circumstances, namely used by themselves and by the ancestors of the land as pathway leading to Rai Bahadur's road for 40 or 50 years. The judicial committee in the case to which I have just now referred to, the present controversy referred to, made the observations which are pertinent to the present case. Lordship said no object of statute was to make more easy the establishment right of this description by allowing an enjoyment of 20 years, if exercised under the conditions prescribed by the Act, to give without more a type 2. This is, my lord, followed and right was held. But in this case, my lord,
40, 50 years.
Therefore, the court said, therefore, Eastman right was not necessary to be considered. Then we have another Madras High Court judgment, Division 1937. Here, 1937 Madras 953. At page 956 is a conclusion, right-hand column. It's a landlord-tenant case. It's a case of use of water from landlord's tank. Tenant was using water from landlord's tank for more than 20 years, although there is no provision in the tenancy agreement regarding the same. Establishes the right to use. Court held after considering number of judgments of Calcutta, Lahore, Madras, High Court, etc. Similar facts are very, in my humble submission, is very similar pertaining to our case. Please. Yeah. You have to see the judgments which I'm not troubling enough. You have to see the judgment of, it starts from paragraph, page 954, starts from 44 Madras, then Chancery judgment, Calcutta High Court judgment, 930 Calcutta, everything considered, Madras is also considered. After considering all the judgments that court held at page 9, 5.
Equivalent citation.
Huh?
Equivalent citation.
Yes,
the
decision in that case.
It starts at page 648. If your lordship takes the first, second, third paragraph, page 648. The decision in that case.
Which, of course, is binding on me, and with which I entirely agree, is of greatest assistance to me. The respondents having clearly proved long user for a period of 20 years and more, 20 years and more, started with a presumption in their favor that they were using the water as of right, and no attempt was made to show that they were doing so with the permission of the Jamindar or any fact to negative the claim as of right. Our case also no permission taken. Other cases cited upon this point by Mr. Chanchat in support of the argument were either 30 Calcutta 281, in which reference is made to either 4 Calcutta, 6 Calcutta. No permission. Within. It's understood to be part of within. That's it. And that evidence is there to that effect. What that evidence not, I'm not reading. I will indicate the evidence in my note. In a note argument. This is not is undisputed in this case. Even they did not. So from 1956 up to date of filing of the suit, before the suit, 2009 suit was filed. We had uninterrupted use of this compound, part of the compound, for the purpose of using my tenancy as a showroom. Keeping the cars for a temporary period, 30 to 45 minutes, while the car was in the process of being delivered for fitting the parts or funfair, whatever it may be. It is not really mere parking of cars. It is car was not kept for is not parked there. It's pausing now. As I like my lord's expression, the car paused on the way out for 30 minutes, 45 minutes on that area. And this right was to the knowledge exercised from 1956 to 209. There is not a single letter from the plaintiff objecting to this right. The suit was filed without any letter asking us to refrain from using this right. Not even a letter, if suit was filed without writing a letter to us, without giving a notice, you refrain from doing that. Not even that letter. It was never. In 1960, a letter of written by landlord saying the tenants are objecting because you are washing at the car on that area because they start creating difficulty. And please don't wash it there. And we stopped washing. That is also evidence. So, long use for more than 50 years in this case establish a right which is become indefeasible after 20 years. And plaintiff cannot revoke it. That is not one support. The next point is, my lord, anyways, my lord, observe that this right of user of a which is not really pausing the car in a quarter was necessary for enjoyment of a tenant's right. For the purpose it was taken. This is, my lord, will be mainly question of fact. And we have tabulated the evidence. Our structure is this. The showroom has two frontage. One is the front side facing the pavement of Preschool Street. That's right. And another in the rear portion. Lots of aware of that. So this is just indicating the structure. And I shall certainly give the notes of argument, not evidence in the notes of argument. This way we have framed second right, and then that is not, car is not deliverable from the front side. Car has to be delivered only to the back portion. What are the evidence on that? We have tabulated. In the evidence you have given, I am not reading that evidence, not to read it. Well, next point you have taken that this right has been exercised for so many 50 years. It has not inconvenienced either the landlord or any of the tenants. So why they are objecting to this? Nobody is inconvenienced. No tenants are objecting to this. This is not against factor. This is indirect pressure to evict. There may not, in law, all these rights, factum, give rise to by in law that there is easement of right. Not here, not I will not take much. But will not a judgment of Lord Denning, if I may place that a portion, very as usual style, very lucid. 1965, 1 Queen's Bench, page 173. It was held by Lord Denning, the easement of necessity is implied unless expressly excluded. Page 173. Judgment copy দিয়েছি তোমাকে আর কিছু চিন্তা নেই 11 portion পড়ে দাও তুমি আমার বিপে আছে this is the yes my lord very quick after noting আমার বিপে আছে দেখি দাও কোন জায়গাটা দেখাবে তুমি দেখি allow Mr. Miller. This is the judgment found by Sarvaprio Mukherjee, Mr. Mukherjee. Dekita, my lord has found it already before you can find it. At page, note नहीं देखा नहीं at page देखा नहीं था. But lucid language as usual, Lord Denning. আমার বইটা এসেছে কি? অলিয়ারটা দাও It also reported in All England report. Yeah. All England track করা আছে দাও ভাই। All report তো দাও। ওখানে নোট করা আছে। আমি All Englandটাই পড়ি। All England এখানে track করা নেই। এটা good. This is Millet, also reported in All England reports and 1964 volume 2 All England reports that I humbly draw my attention to. আরম্ভ হচ্ছে এটা argument Lord Denning. Yes. I can see the first paragraph of judgment. Milord, fact will be very clear, then I don't have anything.
Page 178.
178. Mr. Y. Man Ong is a tenant of a Chinese restaurant in Exeter. Running a pure table. It would to factory shop clear with it. What is Milord? There's a duct. The restaurant was located in the basement, so it is becoming stuffy. And it badly ventilated. So it was necessary to have an air duct so as to take the used air up to the roof. This duct will be to be fixed.
নামটা বলেছে এখানে plaintiff বলে বলেছে।
Plaintiff বলেছে।
একই আছে। একই আছে নাম।
Paragraph start, Milord. The plaintiff is a tenant. Can you read the first paragraph? I don't think I'll read anything more. The plaintiff is a tenant of a Chinese restaurant in Exeter called Chopstick. It is situated underground, below number 83 and 84 Queen Street, Exeter. He has a kitchen there where he cooks the food. It is so badly ventilated, however, that it is necessary to have an air duct so as to be fixed on to the so as to be
take the used air
on the back wall for the to take the used air up to the roof. This duct will have to be fixed on the back wall of the building, which belongs to the landlord. It is the point. The plaintiff asked the landlord for permission to erect the duct and to fix it on the back wall, but the landlord refused. Plaintiff now seeks a declaration that he is entitled to erect the duct and fix it on the wall without landlord's consent. To do this, as it seems to me, he has to go to show an easement of necessity. This depends on the circumstances which the lease was granted. The lease was granted for so many years. They then also read the covenants of the lease and then after noting the facts, his lordship kindly come to page 1. Question is, has the plaintiff a right? Yes, that's exactly so. It is not enough that the subject of the grant should be intended to be used in a manner which may or may not involve this definite and particular use. That is the principle which underlines all easement of necessity. If you go back to Rolls' abridgment, you will find it stated in this way. If I have a field enclosed by my own land, that is compound in this case, on all sides, and I alien this close to another, he shall have a way to disclose over my land as incidental to grant, for otherwise he cannot have any benefit by the grant. I would apply these principles here. Here was the grant of a lease to the lessee for the very purpose of carrying on a restaurant business. It was to be popular restaurant and it was to be developed and extended. There was a covenant not to cause any nuisance and to control and eliminate all smells and to comply with the food hygiene regulations. That was a definite and particular manner. in which business had to be conducted. It could not be carried on in that manner at all unless a ventilation system was installed by a duct of this kind. In these circumstances, it seems to me that if the business is to be carried on at all,
Next paragraph.
next paragraph, see, there is one point, etc. In our case, unless you have the backyard delivery, we cannot carry on the business. That evidence, I think, we are very conclusively proved. Hospi passage দরকার নেই, ছেড়ে দাও, ছেড়ে দাও, next point is, it is also, as my lord may have observed, a part of tenancy, or what is called incidental to tenancy. That is the expression, if I may borrow from my lord observation. That is, right is derived, that claim is based on statute. This is a tenancy governed by Tenancy Act. Both 1956 Tenancy Act and current one. The definition of premises means any building or part of the building or any heart or part of heart let separately and includes the gardens, grounds and outhouses, if any, appertaining thereto. So this is 4 ways are open, is totally appertaining to compound. What for they were given? Why these 4 openings of 11 foot each wide? Why that was given? If the front of the intention was that only front side shall be used, front side was blocked by glass from floor to ceiling. And why these 4 openings given? Which 4 openings may not absolutely adjunct to the compound, for access to the compound. And we have used it, all tenant uses. Now, this is, we relied on 2 sections of the Tenancy Act, which I lordship knows, but in a note we have given that note. Then not come Exhibit A. That is the document which they say that is agreement of tenancy. We have now humbly submitted to your lordship that is not the case made out in the plaint. Lordship will be amazed to know that is Exhibit A, the document which is annexed, is not referred to in the plaint in any paragraph. Not even in the list of documents relied upon. In the plaint has to be even in that it is not relied upon. Not. So agreement tenancy is a case made in course of evidence by PW1, their own witness. Now, what is PW1? He was 7 years old when this agreement tenancy, they call Exhibit 1 of 1956, was executed. He was 7 years old. He cannot be because the agreement said so. He has nothing to do with this executive document. On the other hand, my witness, DW1, he is now 92, 93 years old. He was about 26 years old and he was looking after the business and his signature appears on the document. So he is a competent witness to speak on this document, Exhibit A, what are the purpose and why it was done. But PW, and on the other side, there has been no competent witness to say that. This is many of our text, our argument, and we are given the evidence of PW1 where he admits how old was he, etc. Now, he is not a competent, that he had no personal knowledge, he cannot compete. So Exhibit A, we have also taken a point, because Lanet was hinting at section 91, 92, if that is taken true. It is, we have stated the following most important terms of tenancy, namely area, location, identity. Those are not mentioned in that agreement, which is Exhibit A. And it is humbly submitted, settled law. If all the terms of a contract are not recorded in that contract, then 91, 92 has no application. This is second proposition. Next is the ambiguity in the agreement. They say 4 ways, 4 openings. What is meant by that? For that you need oral evidence. In fact, the plaintiff has introduced oral evidence to show the terms of tenancy. namely, area of the tenancy is 4,400 square feet. That is not mentioned in that Exhibit A, but plenty were given said orally. I have not objected because oral evidence is admissible. He has themselves done so. Next, we have summarized what are the terms of tenancy which are not mentioned in that. In paragraph 42 of our notes, there were a number of essentials. Therefore, no applicability on that, my lord. And we have also relied on another well-known proposition. The subsequent conduct of the parties show what are the tenancy terms, agreement, what is what contract. For that, my lord, we relied upon AIR 1975 Supreme Court, page 32, paragraph 10 and 17. Here, subsequent conduct.
Paragraph 7.
Paragraph 10 and 17. Now, this is a very unique case in the sense the Supreme Court has differed from Privy Council. On English law and Indian law is different. Paragraph 10. Whether subsequent interpreting statements made by parties to a written instrument is admissible in evidence to construe the written instrument is not free from doubt. Then English judgments are cited, all House of Lords, etc. English, Supreme Court differed from House of Lords. Let kindly come to Miller, paragraph 17, conclusion. After noting all the judgments, so many judgments, come to paragraph 17, that is Indian law. We are not certain that if evidence of subsequent acting under the document is admissible, it might have the result that a contract would mean one thing on the day it was signed, but by reason of subsequent event, it would mean something a month or year later. Subsequent interpreting statements might not always change the meaning of a word or a phrase. A word or a phrase is not always crystal clear. When both parties mean this, both parties subsequently say, by the words or phrase which is in the context is ambiguous, or four ways, the inquiry is to what the intention of the parties was from the language used. And why is it that the parties cannot clear the latent ambiguity in the language by a subsequent interpreting statement? If the meaning of the word or phrase or sentence is clear, extrinsic evidence is not admissible. It's only when there is latent ambiguity, in our case, four ways, that extrinsic evidence in the shape of interpreting the statement in which both parties have concurred should be admissible. They have given interpretation, we have given interpretation. Parties themselves might not have been clear as to the meaning of the word or phrase when they enter into the contract. Unanticipated situations might arise or come into a contemplation of the parties subsequently, which would sharpen their focus, and any statement by them which would illuminate the darkness arising out of the ambiguity of the language should not be shut out. In the case of an ambiguous instrument, there is no reason why a subsequent interpreting statement should not be inadmissible. Question involved is the fact that the parties to a document and particularly to a contract have interpreted these terms in a particular way and have been in the habit of acting on the document in accordance with that interpretation. Any admissible guide to the construction of the document in case of an ambiguous document, the reference construction of statute given. But as you say, ambiguous, an answer must be yes. Then not Indian appeal relied upon, and all this judgment. That in our case,
Yes, sir. Next one.
In our case, my lord, that conduct of the party shows that by the tenancy change agreement, the compound adjunct to the rear portion was reusable by the tenant of the showroom. In fact, evidence, Dr. She may know, that evidence is all other tenants of Kandani Mansion use that compound for parking of the cars.
All right, come next to with your notes of argument.
Yes, my lord. Yes, my lord.
Heard in part, adjourned to before vacation.
Yes, that has been my note.
1 day.
Yes, bolo. Whatever.
17 December.
Kabe?
17th.
Yes, I am. Okay.
18, 19.
It would be on 19th.
19 December.
19 December. Ki baat puchte?
19th Thursday. 19th Thursday. Because this weekend up to
17th. 17th?
No, up to 18th I'll be in Port Blair.
Oh, well.
I return on 18th.
On holiday or on what?
Then after vacation.
Professional. I leave it to your lordship. Not because 19th is good for me. 20th,
Arbitration.
19th, 20th.
But what come pleasure? That is what.
19th, 20th, I have no problem.
Then after vacation, sir.
19, 20 has no problem, he says. 19,
19.
20th করবো 20 হ্যাঁ 19 সকালে করে দিন 19 2 p.m.
Yeah, they will conclude. I will add something and there are
19 December.
I'm getting
19 2 p.m. Oh, bless you.
Item number 27.
This is my application.
Just
Yes,
But I have taken out
Wait, take breath.
taken out by the
অ্যাপ্লিকেশনটা বোধহয় আসেনি 16 তারিখে আসার কথা আমরা আচ্ছা
For final accounts. Is it on?
for the dissolution, my lord. Now they have taken out an application, being one of the contributories, my lord. They want that whatever the money is lying with the official liquidator, the surplus amount needs to be paid to them. Now this is the company which was the winding up order was passed way back in 68, 66, I believe, my lord. Now subsequently, some of the assets have been sold. Now the entire sale proceeds are lying with the official liquidator. In the meantime, in the year 2010, there was an advertisement claiming the invitation for the claims, my lord. So nobody has turned up. Now in the year 2024, the contributor is coming with this application that he wants to lodge his claim and whatever, because since the surplus amount has not been transferred to the RBI account as it happens after the dissolution, so he's claiming the money over, they are making the claim over that money which is lying with the official liquidator. Now my instruction is this: since 2010, the last advertisements for the claim of invitation, my lord.
Have you filed any AO against this?
No, this is my application. Their application is not appearing, I believe.
My application is CA number 7 of 2024. That is about to be listed on 16th.
But my instruction is to withdraw this application. In the meantime, let there be a direction upon the official liquidator to make an advertisement for further claim, because we do not know.
Do one thing.
Yes, my lord.
First is they will file a statement of accounts. Is it there?
Statement of accounts, definitely, because I am also carrying one history sheet, and the fund position is also indicated here.
So you come in that form, in the report form, a statement of accounts. Then you publish a newspaper report inviting any objections or inviting any views.
But my lord, I want to withdraw this application for the dissolution and let there be a direction upon the official liquidator to make a fresh advertisement claiming for the invitations. So if this can be done, so because now like this one contributory has come up.
Some
Second
others may come up.
Yes, that is why for just okay. I think so it will be
6 is your application.
yes, my lord. It's just an abundant caution, my lord, that if there is a direction for making an advertisement,
File
it will
six.
not
6 is
prejudice
your
the interest
application.
of the other.
My application. 7 is my application, and Lord, with the suggestion coming up from my learned friend, Lord, I don't stand in the way. Lord, that's a fair submission also, my Lord. Lord, I understand.
It will
Lord.
not prejudice the interest of any of the creditors
In
if
that-
at
in
all
that
there are
case,
any creditors,
You
my
file
lord.
you come with a statement of accounts, latest position,
Yes, my lord.
and you come first, then I will pass direction for publication.
Publication.
Your learned,
With a copy to me, my Lord, if
let it be filed first. Your learned official liquidator shall submit a statement of accounts of the fund on or before the returnable date. Fix. How long would you take? Next, after vacation.
After vacation.
14 January. You will know?
Okay,
Fix 14 January for filing the report, and
before vacation, they can be able to make that report, my lord.
Lord, 16th was my application returnable.
16, all right. Let it come 16.
Oh,
If you are not able to do that, I will extend time.
okay.
When 16th is fixed, let it
Yes,
come
ma'am.
on that date.
I'm great. I'm
I'm
great.
Obliged. May I keep Nani madam, Mr. Mitra, I was trying to tell Mr. Mitra, his grandson's wedding is on those days, my lord. So I was trying to tell him, well, if your lordship can keep it in January only, on 19th onwards, my lord, Mr. Opposite Mitra's son's wedding is.
Yes, I got
I was trying to tell him he was not following at that point of time, my lord.
6, 7, 8.
Any day, Peter, any day. 8, my lord. Any day for us, any day is fine.
8 January.
10th.
10 January.
10th.
No, not 10th. 8, keep it 8.
8.
Sir, 8 is okay.
I'm extremely obliged, my lord. I was trying to tell him he was not following it. But
All right.
when he went out, I explained to him. Then he also realized.
Lordship, in this matter, Mrs.
Your Lordship, I appear for the official liquidator, Your Lordship, in this matter. And if Your Lordship will see, here, Your Lordship, the official liquidator has filed this application. This company had gone into winding up, Your Lordship, in 2002.
Who filed this application?
The liquidator. The liquidator is the applicant, Your Lordship, praying for that Form 71 under Rule 167 of the Companies Court rules be kept on record, and for the order of disbursement, Your Lordship. Here, the only property of the company liquidation, the tea estate, was sold, and the amount which the liquidator received is around 4 crore and odd.
Where is the liquidator?
So I appear on behalf of the liquidator, Your Lordship. If Your Lordship sees the judge's summons, the prayers therein.
What is judge's summons?
If Your Lordship sees this Form 71 under Rule 167 of the Companies Court to be kept on record, that Form 71, Your Lordship, is annexed to the application, which is at page 22. This is the certified list of proof which has been admitted or rejected has been mentioned in that, Your Lordship. Your Lordship, as to after the order of winding up, Your Lordship, there was a direction to take possession of the tea estate of the company in liquidation. The liquidator took possession of the tea estate, and there were pursuant to the directions of this court, the tea estate was sold and the sale was confirmed. The liquidator has received the entire amount, Your Lordship.
This 264 was the sale proceeds.
No, Lordship. The sale proceed is 4 crore and all, Your Lordship, which is mentioned at page 5, paragraph 8.
What is this amount? 2.64?
This amount, Your Lordship, is the amount which has to be distributed, Your Lordship. This is one of the creditor, ATEFPO. If Your Lordship sees the detail, Your Lordship, the detail is mentioned also in the application. This is Assam Provident Fund Commissioner, Assam Tea Employees Provident Fund Organization, which the detail is mentioned at page 9, if Your Lordship sees. And the amount which we received after the sale was it's mentioned at page 5, paragraph 8, if Your Lordship takes. It's 4 crore 13,90,369. And these are the amounts, these are the claims which have been filed by the creditors. The amount which has been claimed, the amount.
So you want to pay 2.64?
Yes.
To Assam?
Assam Provident Fund Commissioner. And this will, if Your Lordship takes page 9, and that amount Your Lordship will find is the same.
Admitted amount 2.64.
Yes, yes. This we want to make payment to them.
What is your
Thereafter,
statement of what is your status of statement?
Your Lordship, here is the list of creditors. Yes, if Your Lordship takes page 22, is the list of the proofs which was given, what is admitted and what is rejected. This is what is the prayer A.
What is the fund available?
I mentioned, Your Lordship, 4 crore 13,90,369 at page 5, if Your Lordship takes.
Where have you mentioned that?
Page 5, paragraph 8. Your Lordship will find, I state and submit that pursuant to the order of this Honorable High Court, the sale of movable and immovable assets and properties of Kamini Tea Estate was confirmed in favor of the highest bidder for rupees 413,90,369. It is mentioned that the said highest bidder deposited the entire sale consideration. Accordingly, the official liquidator handed over entire assets and properties. Thereafter, if Your Lordship takes, we have mentioned as to who all had filed the claims, and the detail which we have given Your Lordship is, if Your Lordship kindly takes page 8, paragraph 18 once. Page 8, paragraph 18 is regarding the claims which we invited.
Page 9, that is a chart where different claims we have mentioned.
Yes, amount rejected, and Your Lordship, it has also been mentioned which are
basically what is the
claims.
admitted amount. We have mentioned what is the admitted amount.
Yes, if Your Lordship see, the first is amount claimed. Second
That is by the Assam Tea Employees Provident Fund.
Yes.
You are concerned with
all of them, if Your Lordship sees.
All of them there are there, but right now you are concerned with the one only.
No, Lordship. If Your Lordship sees the paragraph C also. Paragraph C is to the workers.
Paragraph C.
Yeah, the prayer C. And the list of workers we have annexed at page 25. So prayer C is regarding 38,75,000.
How this will be disbursed? How this amount will be disbursed to ex-employees?
If Your Lordship sees, the we have said that they will have to give the indemnity bond also. If Your Lordship see prayer E, as far as the legal heirs are concerned, they will have to give the indemnity, and the list is at page 25.
You furnish a list of these persons. Have you got the list of these persons?
Yes, page 25. Workers' claim.
Community estate.
Yes. So they are the workers from page 25 to page 59 are the list of these. And we have mentioned this in paragraph 20. The pleading in respect of this is in paragraph 20. And if Your Lordship sees page 11, we have given the entire this thing. If Your Lordship sees present available fund, amount to be paid to ATPO, thereafter to be ex-workers. So there are preferential creditors, there are ordinary
One
creditors.
thing,
yes.
You first disburse the amount of 264.
And your lordship, regarding the work, if your lordship just kindly once take page 11 once. Page 11.
I'm seeing page 11. This is open to me right now. Your
Yes.
first preferential claim is payment to Assam Tea Estate Provident Fund of account.
Yes. And
Let
even
this-
the workers are in
Let
a category of
this be
preference.
done. Preferentially,
well.
it is first in your preference. Let
Very
this
well.
statutory liability be disbursed.
Very
Come
well.
with a statement, then the rest will be declared. Come one by one. In one go, the whole money should not be disbursed.
Very well. Very well, your lordship. If
Because
your lordship,
in
yes.
how this
The
money
only
is kept.
difficulty, the money must be kept in the account of the liquidator in some kind of a fixed deposit. Miss Burman, is the liquidator there?
The liquidator is not here.
Lordship, the entire consideration must be lying in the either the fixed deposit amount or the amount of the liquidator in the name of this company.
Amount, that is the 4 crore 11 lakh or something like that, must be attracting
Yes.
some interest. So there must be a
I'm
statement
sure.
of accounts
Yes. I'm
with
sure.
the interest. So let that be filed.
Very well. We'll do that. And your lordship is
And let me
allowing
know
trade
how the
A and
money,
B?
how
Very
the
well.
money is kept, whether in fixed deposit or in other investment or like that.
Very well.
A statement of accounts shall be filed by the learned official liquidator, indicating clearly how the available fund is invested or kept or preserved, along with income by way of interest, if any. Same shall be submitted in this court on or before the returnable date. The matter will appear in the list on 16 January.
Would it be your lordship's pleasure to keep it in December only, your lordship?
No, not December.
Very well. Well,
If you are
I'm
able to
grateful.
keep it, if you are able to prepare it, mention it, I will include
Very
it.
well. I'll do that. I'll do that. I'm grateful.
And for the official liquidator, your lordship, your lordship kindly takes up the summons for direction, pressing prayers A to E, my lord, A to F, my lord. Here, the valuer should be directed to submit the valuation report, and subsequent thereto, all the movable
Let
assets
A,
and
B be allowed. Let them valuer be directed to submit the report, valuation report.
yes, and the C, D, E, and F.
Let this be done first.
The valuation report has to be submitted. Then
Let
subsequently,
it come, then one by one orders will be passed.
because in one shot, if this directions are the prayers are made in one direction, my lord, then the entire exercise can be completed by the end of the January, and let this matter be also be kept alive. In the meantime, they will come with the compliance report, because it's the entire exercise that after the valuation report there will be an advertisement, there will be an e-auction, and then the highest bidder, whoever will be the highest bidder, will come up with that money and will come before your lordship. The possession will be handed over. That it's a similar way, the way in another matter, my lord was pleased to pass an order for making the cell confirmation, my lord. The cell can be confirmed in this fashion, if your lordship so
First,
pleases.
let the valuation report may come. The learned official receiver,
Of liquidator, my lord.
liquidator, moves the instant application, praying for various directions. Full stop. Prayer A and B are allowed for the time being. Direction is given to Mr. Alok Kumar Ganguly, the valuer, to submit the valuation report as prayed for on or before the returnable date. Let the matter appear in the list on 20th December. Should it be possible to file
2 weeks?
2 weeks?
Yes, I think so. The valuation report is ready, my lord. He can submit
20th December.
before the assistant registrar company, my lord.
Yes.
Be filing it.
The
Deeply
suit will appear on 20th December for further order.
Deeply appreciated.
দরকার নেই কোনো, যা বলেছি ঠিক মতো উল্টো পাল্টা লিখলে তখন পাঠাবে, হোপফুলি ঠিকঠাক টাইপ করবে।